Good morning, Judge.
Good morning. May we start?
Good morning. Yes, we may start.
Thank you.
Morning.
Morning. Morning, my lady. We may start when you're ready.
Thanks, Nicole.
Thank you, my lady.
Morning.
Morning, my lady.
Morning.
Good morning, my lady.
Morning. You may call up the matter.
Thank you, my lady. As the court pleases, my lady, this is a matter between the Special Investigating Unit and Minister of Correctional Services and 6 others. Case number GP08 of 2019, appearing in the Special Tribunal of South Africa before Madam Justice Mudiba, 24 November 2023. My lady.
Thank you.
May it please you, my lady, I appear for the applicant with Ms. Ramaimel.
Thank you.
May it please your ladyship, and my name is Sarel Becker from the Johannesburg Bar. I appear in this matter on behalf of the second respondent, that's the Independent Development Trust, instructed by Weavent and Weavent Pretoria. There is no appearance for the first respondent, the Minister of Correctional Services. Thank you, my lady.
Thank you.
May it please your lady, I appear for the third, fourth, and fifth respondent. My name is Shem Simon from the Johannesburg Bar. I'm appearing together with Mr. Stiliano, also of the Johannesburg Bar, and we are instructed by attorneys Ramsey Weber.
Thank you, Mr. Simon.
Please, the court, my lady, I see I have a problem with my camera. I'm trying to rectify it so that you can see me properly. My name is Claudio Bollo from BBM Attorneys, and I represent the 7th respondent, my lady.
Thank you, Mr. Bollo. Mr. Motepe?
Yes, thank you, my lady. My lady, there are various points in limine raised. I'm in your hands whether we deal with those first or I deal with everything and the respondents will respond accordingly.
Yes, please. The latter.
As a court, please. My lady, perhaps I must start with what we say seems to be the main point in limine, that the tribunal does not have jurisdiction to deal with this type of reviews. We thought the legal judgment had dealt with the issue, but we see that the 7th respondent is still persisting with that argument. The heads were filed yesterday by the 7th respondent, and then they argue that because the tribunal is not the court, it can't grant orders in terms of section 172, one of the Constitution, because it refers to a court. So they say this tribunal can only deal with common law reviews. That is the argument that they mount. And we say that...
Mr. Motepe, I wouldn't want you to waste a lot of time on this point.
Yes.
Right. If you look at the argument as set out in their heads, they are saying the tribunal cannot make orders in terms of section 172 of the Constitution.
Yes.
Indeed so, right? Indeed so. But that's not why you are here. You're seeking an order in terms of section 82 of the Special Tribunals Act.
Yes.
So leave it to Mr. Bollo to tell us why the tribunal can't give it such an order, can't conduct a legality review in terms of section 82 of the SIU Act, which is what Ledla says, right?
As a court, please.
An order of constitutional invalidity. You may have said so in your papers, but that was pre-Ledla.
Yes.
Yeah.
Then, my lady, there's an issue of list pendants. That the IDT has brought a similar review, although they accept that ours is much wider, in the High Court in Pretoria. So they say it is prejudicial that the tribunal must now deal with this review? Well, firstly, as the SIU, we act in terms of the proclamation. It has authorized us to investigate and bring the review either in the tribunal or, of course, in the High Court. So firstly, if they were unhappy of us coming here, we say the first port of call was for them to attack the proclamation, which authorized us to come to this tribunal.
They've not sought a stay, right? They've not sought a stay of this application.
Yes, indeed.
So if there's any prejudice by way of cost, it can be addressed at the appropriate forum.
Precisely, Malay. And we say, therefore, that argument cannot stand with respect. Then there's an argument that we ought to have cited all the trustees. We've dealt with that in the supplementary heads. The SCA has developed the law to say that you don't need to cite all the trustees as long as the trustee is there. Particularly where you are dealing with a trust that is involved in economic activity, because it is so that particularly with IDT, that the trustees change frequently. So in our heads, we give the SCA decision, and we also refer to the High Court decision in Pretoria. In fact, in that case, Justice Labus Kahne did emphasize the point that particularly where the trust is involved in economic activity, it is too formalistic to then demand that all the trustees be cited. So we say that point also must be dismissed. Then there's an issue that the SIU relies on hearsay. Now we say that cannot be correct. Our case, we have attached as a result of our investigation, we've got about 4 affidavits. That of Mr. Nzandeni, of Mr. Reddy, Mr. Jugath, and Dutoy. The forensic investigation of Nexus, which was authorized by National Treasury, it merely supports what the SIU already found in its investigation, and so far as irregularities are concerned. And the other report is that of the Auditor General. Equally, they merely support what the SIU found. But a further point needs to be made. Even we're not dealing here with the witnesses who deal with, for example, having witnessed an accident. We're dealing here with documents, objective documents. Anybody can have a look at those documents and see that the prescripts were not complied with. And we simply present those documents before this court. The investigators obviously were not there when some of these decisions were taken, but they have had access to those documents. They have interviewed relevant witnesses, made affidavits, and then they're before the tribunal. So with respect, that argument also cannot stand. There may be perhaps where the SIU sought to rely on the Nexus report without referring to source documents. Perhaps in those instances, the point might be valid. But our case is not disturbed by that, because the direct evidence that we have, the affidavits that we have, are sufficient to establish the case with respect. And my lady, there's an issue of prescription also raised by one of the parties. Now, there are two decisions on that. The leadership judgment in the Motswening matter is under appeal. Then the second judgment, which differed with the leadership to say that prescription wouldn't apply, particularly in instances where the SIU brings the application on its own, not as a co-applicant, but brings the application on its own, that the prescription wouldn't apply. But I want to add a further argument.
Yeah, Mr. Motep, in Motswening, the issue under appeal is a factual point. It's not a legal point, right? The legal principles on prescription are quite clear. So what they are appealing is a factual finding that I've made.
Well, my lady, we are also appealing the prescription. I'm involved in that appeal.
You are also appealing the prescription?
Yes, on the prescription issue. Perhaps let me just make this one submission and I'll leave it there. the arguments that we mount is that one, for example, in this case, IDT DCS could not have issued summons to sue any of the respondents for a debt until a court has made a ruling on the legality point. That firstly, the appointment was unlawful. And thereafter, the court exercised discretion. Should there be disgorgements of profit or not? So we say, until that ruling is made, we cannot know what we can sue.
That approach I don't agree with. That approach I don't agree with.
Jurisdiction
starts running. It starts running when the SIU, not the IDT. Remember, the SIU is coming in its own name, right? In its own rights, even though it is stepping into the shoes of the IDT, as it were, but it's coming in its own name. So it is the SIU that has to have knowledge of the cause of action, which kicks prescription, which causes prescription to start running.
Well, I hear what your ladyship says. In any event, I think the point being made by the respondents, and we'll hear them when they argue, is that because we step into the shoes of the IDT and the DCS, prescription would have started running much earlier. But if it is the latter, then we are comfortably within.
I mean, that would defeat the purpose of the SIU Act.
Precisely. But if it is the latter, then we all accept that, then we are comfortably within the period, because the SIU only, the appointment was in 2017. It investigated from 2018, and it completed around, the initial report around May 2018, but the final, after further inquiries, it was completed in September 2019. The application was issued in December 2019. So
well within the prescription period.
Sorry, my lady?
It's well within the prescription period.
Yeah. Yes. So we say we are comfortably within. Then I just want to check what other points in limines are there, but I believe I may have dealt with.
There's an abuse of process point. There's non-joinder.
The non-joinder I've already dealt with, in a sense that the trustees, we don't need to cite the trustees, but so far as the officials, yes, but so far as the officials are concerned, what we have to cite is the IDT. The decisions are taken by the IDT. So even if otherwise you would have a situation where you have decisions taken by various officials within the IDT, and you've got to cite all of them. That is not what the law demands with respect. So far as, because they raised the point that those officials might have a direct interest, but the recommendations of the SIU are that those officials must face disciplinary hearings internally. So that takes care of that. So far as the review is concerned, it is a decision of the IDT, the decisions of the IDT that we attack. So that cannot be valid with respect. Then the issue of the dispute of facts. On the legality, there can never be a dispute of facts. And your ladyship would recall that the IDT is not opposing. In fact, they say they support the relief insofar as the review is concerned, because the other respondents are mere spectators. The IDT is the one that took the decision. So it knows that it had prescripts, it did not comply with them, and it accepts that. In fact, the other respondents, 3rd to 5th and 6th and 7th, if one looks at the affidavit, so far as the legality, they say, particularly, perhaps let me exclude the 6th for now, the 3rd to 5th and the 7th, they say, we don't know what processes were followed. We're not aware that there were irregularities, and we can't be blamed for that. That's what they say. And perhaps where they may claim dispute of facts, it is when we deal with just an equitable remedy at a later stage, because we say, this court is not the tribunal. We are not today seeking that we the profits be disgorged immediately, we say they must give their accounts with supporting vouchers within a period, and then the SIU will have an opportunity to file its own report so far as the accounts is concerned, some sort of a debatement, and it is only then that the tribunal will be asked to then disgorge the profits from the respondents. So that perhaps there can be dispute of facts there, but that is at a later stage. So far as the irregularities are concerned, there cannot be dispute of facts. There are none, in fact, if one looks at this. What makes it worse is that the IDT, as I say, they are abiding while supporting the application. But the sixth respondent, very interestingly, they were opposing, they filed the affidavit, then they filed notice to abide, and then notice of withdrawal. So they've withdrawn their opposition. And the leadership would recall that they and I'll deal with that, they played a huge role in the appointment of the third to fifth respondent and the seventh respondent in the second tender. So they've withdrawn their application. So there cannot be any dispute of facts because we say they were appointed unlawfully, being the sixth respondent, and then they went on to appoint the third to fifth and the seventh, meaning those appointments are tainted. And even on the affidavits by other respondents, nowhere do they dispute the factual amendments that we make, and they can't, that the Manyaleti was appointed unlawfully. So there can be no dispute of facts on the irregularities with respect, my lady. So we contend that the points in limine should be dismissed with costs of to cancel, and if the ladyship pleases, I may proceed to the merits then. So, my lady, with regards to the merits, and I will give the reference, not necessarily having to go to the relevant pages, except where a point needs to be stressed. But the first point that needs to be made is the genesis of the irregularities. It is, in brief, the fiscal dumping committed by the DCS Correctional Services and the IDT. The evidence is quite clear, and Mr. Reddy also submitted an affidavit which we rely upon. The DCS Correctional Services, they set on a budget for some time, and later on, when they realize that they'll have to return the budget to National Treasury, then they swing into action. They, in fact, in some of the letters, they specifically say that we need to spend this money now so that the money is not returned to Treasury. And we say that is what has colored all the decisions taken subsequently. Everything was done in a rush, ignoring the prescripts that were applicable. And Mr. Reddy explains that fiscal dumping exercise on its own was unlawful. We detail that in the funding affidavit, but I must indicate that we are not reviewing the decision of the DCS to appoint the IDT. We give that because we don't have relief asking for that, although we have made arguments to that effect. Our view is that while the profits are returned to IDT, then they go back to DCS because they're both state organs. So but we rely on what we state in relation to fiscal dumping to show that all the decisions taken subsequently, they were all made in a rush and ignoring the very clear prescripts. So the starting point is that in January 2011, and now I'm dealing with the rushed appointment of the IDT, the party started interacting in January 2011. That your leadership finds at paragraph 28 of the funding affidavit at 001-15. So that is the first interaction. They interacted. Then in 3 And for August, there were workshops between the IDT and the DCS as to how the DCS can then engage the IDT, assisting it in its programs. Then the IDT is appointed on the 16th of August by the DCS. What is important at this stage is that between 7 and 15 August, the appointment, your leadership finds that paragraph 29 of the founding affidavit, but also annexure HSN1 at page 001-102. That is the appointment of the IDT. What is of importance is that between 7 and 15 August, there are email exchanges from the DCS prescribing to the IDT that here are the service providers that you must work with, that you must engage. So as the IDT is appointed and it has its own supply chain policies, but somehow it is told that you must use these service providers. We say that obviously is the first irregularity. We are dealing with huge amounts of money. As we'll see in the first contract, we were already in the 35 million that was paid, and we say that there ought to have been an open tender, not prescribed service providers. There ought to have been. So between 7 and 15 August, and the emails, my lady, appears at HSN4 at pages 001-168 to 001-171. So these are and the service, the list of service providers is also attached there. So they on 18 October, the DCS then gave the IDT the official letter of appointment, indicating once more that it must use specific service providers. Now, Mr. Nzandeni is a very central figure in this entire application. His affidavit is attached as Annexure F82. He accepts and he says that the way they were rushed to spend these huge of monies within a period of about 4 months, it was impossible to do. It was too much pressure for them. Yet he says that in his affidavit. And he says this is purely because of poor planning by the correctional services and the IDT. And he says that at paragraph 6 and 7 of his affidavit, which is FA2, is at page 001-95. Now, as I've indicated, Mr. Reddy states in no uncertain terms that this is a classical case of fiscal dumping, and he deals with that at paragraphs 42 and 40. No, we deal with that in the funding affidavit at paragraph 42 and 43 as 001-20. But there can be no dispute that that was fiscal dumping. Then, my lady, coming to the appointment of Bakoni Sekelek, and I realized immediately that one of the points in limine that I did not deal with was whether this tribunal can have regard to DCS or tender one. Let me put it that way. That it is authorized. The argument is that the tribunal is authorized by the Government Gazette to deal only with the second tender, which is DCSSF02, not DSSF01. But as I deal with the merits, and perhaps that is a good starting point to show through the merits that the two are interrelated. They cannot be distinguished from each other. Then my learned friends will respond.
Yep. This respondent has cherry-picked extracts from the proclamation.
Indeed.
They've not looked at the proclamation that you are relying on.
Indeed. In fact, they did not. They only looked at also the schedule, but they don't look at the proclamation itself, yes. Because proclamation itself is quite clear, and there cannot be any argument that the two are indeed related. Now, with the first appointment, the facts are that the TAC, which is the authorized decision maker, appoints the Sekelek JV joint venture, Sekelek joint venture, appoints them on 7 December 2011. Unbeknown to them, Mr. Nzandeni had already appointed the service providers, that joint venture, on the 21st of November 2011. Again, there's no dispute on that because Mr. Nzandeni gives the Sekelek joint venture letter of appointment on the 21st of November 2011. They sign it on the same day. The reference is HSN8 at page 001-215 and 216. So that is an irregularity that cannot be gainsaid. In fact, the evidence shows that even before the appointment of the joint venture, Mr. Jugath from the IDT was already communicating with Mr. Adlam from the joint venture as early as 9 November, 10 November 2011. And Mr. Adlam in his affidavit, he says, no, in fact, I was already called in August 2011 to submit the relevant documents so that for the IDT, not DCS, for the IDT. And what Mr. Adlam was requesting me to submit on the 10th of November, I actually told him that, no, but I've already submitted those documents on 2 September. Do you want me to submit them again? And Mr. Adlam then, Mr. Jugath said, no, then it's fine if you had submitted them. The references to that evidence, I can just give references. The funding affidavit is at paragraph 47 at page 001-27. The answering affidavit of Mr. Adlam, who confirms all these email exchanges, it's at paragraph 116 at 005-79. And then the email exchanges themselves, or the email itself, is FA5 at page 001-1282. The point being, even before the appointment, already there were communications between the IDT and the joint venture. And of course, as I've indicated, Mr. Nzandeni appoints the Sekelek JV. I keep on confusing the two because there was Sekelek JV in the first appointment. Then in the second appointment, it is Bakoni Sekelek. So I keep on mixing the two. I apologize for that. Then, as I've indicated, Mr. Swart, on behalf of Sekelek, signed the letter of appointment. That letter, which he signed, is HSN9 at page 001-218. Again, the date clearly reflects 21 November 2011. The approval by the TAC on 7 December, your leadership will find as Annexure HSN12 to Mr. Nzandeni's affidavit. It's at page 001-229. So they signed that on the 7th, believing that they're giving approval, but of course, Mr. Nzandeni had already appointed. The difficulty with that, of course, is that it is regular, but also they simply chose Sekelek JV without even asking for quotations from other service providers or open bidding. And we say this was a matter where open bidding was required. You cannot, because the DCS was sitting on a budget, not doing anything for months on end. And last minute, they wake up and say, let's do it, and it's all rush. That is not what emergency procurement is for. That was not an emergency. It was self-created agency, if I may put it that way. Now, on those facts, we say the initial appointment is wrong in law and has got to be reviewed and set aside. And of course, the profits that were obtained, they've got to be disgorged. I say so, but we'll deal with that when we deal with the exact amounts. But I may just point out the following, because these facts are important. The appointment was cancelled on 5 January 2012, after Treasury raised issues about this. That is also common cause. So it was then cancelled. The reference, my lady, even starting even with Mr. Adlam's affidavit at Annexure AA24, there is a letter of cancellation. AA24 is at page 005-1103. At the funding affidavit, we deal with that at paragraph 77, page 00-38. So there's no doubt that that contract was cancelled. But Sekelek JV says the contract was cancelled. Therefore, the SIU cannot now come back and ask for a second cancellation. But we say they are wrong. We're not asking for cancellation. We're saying it must be declared void ab initio. So it will be as if it was never there. And perhaps they misunderstand our case so far as that is concerned. And why that is important, although it was cancelled on 5 November, there were payments made even, on 5 January, sorry. There were payments made even after 5 January. Not only that, the written agreement is only signed on 2 May 2012. That is months after it was cancelled. And then they and I'm talking Sekelek JV, they say in the affidavit, Mr. Adlam says, look, because they cancelled this contract, we're entitled to sort of a punishment for that cancellation in the amount of 2.6 million. And that was one of the payments that ultimately constituted the entire 35 million that we say they were paid. So they get that 2.6 million because of the cancellation, not because of services rendered, because of the cancellation. Then they say, we also negotiated with Ntsandi. They say, Mr. Adlam says, and this is also very, very important. And this is at paragraph 183 of the JV's Mr. Adlam's answering affidavit at page 005-107. But we say paragraph 182 and 183 are very important because Mr. Adlam says, yes, after it was cancelled, we negotiated with Mr. Ntsandeni that we must be paid this 2.6 for the cancellation. But in addition, they also negotiate with Mr. Ntsandeni, only Mr. Ntsandeni, that they must be paid 4.6 million for their intellectual property. That's what they say. But of course, they were contracted and paid handsome amount of money to develop the necessary documents and the designs in stages 1 to 4 of the tender, and they got paid for that. As to why do they still need, must they still be paid 4.4 million for these services? It is beyond us. But in any event, we say that there are then grounds, there are sufficient grounds that the profits have got to be repaid. We'll deal with computation later on, but we say clearly the case is established that And we're still talking just appointment under tender 1. It's got to be set aside, and there's got to be a repayment. Perhaps I must also, before I move on, just give the reference of the contract itself, which I say was only signed on 2 May, and I made a note, but now I'll get the note and give it to your ladyship. I will get that note as I proceed. So we say, of course, the appointment was irregular and it's got to be set aside, that the profits be repaid. Now, coming to the appointment of Manyeleti, the evidence of Mr. Nzandeni in his affidavit, and we're now moving to the second tender. His evidence in his affidavit, Annexure FA2, is that he appointed Manyeleti, which is the 6th respondent, on the 5th of January 2011. Now again, the TAC, the Tender Adjudication Committee of the IDT, only purported to appoint the 6th respondent on the 6th of January, a day after Nzandeni had already appointed them. Of course, they don't know. But Nzandeni appoints Manyeleti, which is the 6th respondent, on the 5th of January. Now, this is what he says in the affidavit. And then the 6th respondent, of course, now they've withdrawn their opposition. Then they went and spoke to Mr. Nzandeni, and he filed a confirmatory affidavit. His evidence is that no, but at times I put a date there, and when I signed, I forgot to change the date. So he's suggesting that he would have signed only after the TAC had appointed, either 6 January or thereafter. He doesn't say exactly when he signed, but he says it would have been after the TAC appointed. But of course, this contradicts what he says in the affidavit to the SIU. But there's a little detail that he forgets.
Do you have the reference to the affidavit to the SIU?
The affidavit of the SIU is, yes, Annexure FA2, my lady, paragraph 13. It's page 001-98. Yes, paragraph 13. So that is confirmed. And the letter shows that it's dated 5 January. But what he then forgets, when he now is trying to obviously assist the 60 respondents so far as we see it, is that there is an objective evidence that Manyeleti was appointed on 5 January 2011. And that we find even in the affidavit of Mr. Adlam. So what happened? When the initial tender was cancelled on 5 January 2011, it was not only by means of a letter. Mr. Adlam says the CEO called us into a meeting at IDT offices. That's when they were told of the cancellation. But in that meeting, there was also Mr. Lamola from Manyeleti, the meeting of 5 January 2011. So he was already appointed. So no one can come and say he was not appointed. And we understand why Manyeleti would then withdraw at this stage. They can't dispute this. The affidavit of Mr. Adlam, where he confirms that Mr. Lamola was in attendance, is paragraph 197 of his answering affidavit at page 005-111. And he says there that Mr. Lamola's presence in the meeting was not explained to me, but I only got to realize later that he was appointed to advise on the second tender. And it's exactly what we say. He was appointed by Nzandeni to assist with the second tender. And there he was in the meeting, the very same day of appointment. So this notion that Mr. Nsandeni made a mistake, it's proven wrong by these facts. And as we indicate, Manyeleti has now correctly, in our view, withdrawn the opposition, although we say they should have done it earlier, and we will seek costs, of course, in relation to that. So that is a further irregularity now, dealing with appointment of Manyeleti. Mr. Nsandeni appoints them the day before. The appointment must be set aside based on that. But then there are huge consequences for the remaining appointments because of the setting aside. And we say there can be no dispute that there must be appointment of Manyeleti must be set aside. The difficulty for the third to fifth respondent and the seventh respondent is that their appointment was as a result of Manyeleti's evaluation of the tenders. It is not the TEC of the IDT that evaluated the tenders. I'll show you a leadership. It is Manyeleti. So a tender is issued, bidders submit their proposals. Who evaluates them is Manyeleti. Evaluating in a sense of scoring them. He gives a report to TEC, and I'll refer to the affidavit of Mr. Ditoy shortly. He gives a report to the Tender Evaluation Committee of the IDT. They simply take it as it is, recommend it to the TAC. On the basis of that, the TAC is appointed. Now, it is our law that if the first act is found to be unlawful and it is set aside, the consequent acts that rely, I see there's someone who's coming on, the consequent acts that then rely on that initial act, they become automatically invalid, because without the initial act, the foundational act, they do not exist. They can't exist. And we say, because of that, it is the end of the matter so far as the third to fifth respondents are concerned, and the seventh respondent. Now, if I may just give references to what I've been dealing with. At paragraph 119, see my notes, so it's 119 of the funding affidavit. Yes. At paragraph 119 of the funding affidavit, the deponent summarizes what one of the officials of the IDT who were in the TEC meeting, what that official says. Of course, that official's affidavit is with us. But at 119.7 of the funding affidavit, the page is 001-51, the point is made that the evaluation was done by Manyeleti, and the TEC only submitted the Manyeleti report to the TAC for recommendation. Now, we will show that at 119.8, it says the TEC followed this same process during evaluation of the contractor. So that the contractor was the seventh respondent, and the PSP was the Bakoni Sakelek. So then the affidavit of Mr. Mukobani, I can just give references. Annexure CDT8. It's attached to the forensic investigator's affidavit and Mr. Ditoy. It's attached, the annexure is CDT8. The 11 paragraphs is 6.3 at 001-1666. 8.3 at 001-166E8. Then there's also CDT9, which is the affidavit of Mr. Muketi, who was the chairperson of the TEC, Tender Evaluation Committee. The relevant paragraphs of his affidavit, also 6.3 at 001-1675, also 8.3 at 001-1677. Now, Mr. Dutoit confirms under oath, after looking at even the minutes and interviewing these relevant officials, he confirms under oath that the TEC did not evaluate the tender, and his affidavit is Annexure FA7. He deals with this at paragraph 9.1 at page 001-1580. He also deals with this at paragraph 21.4, that is in relation to both service providers. At paragraph 21.4 at page 001-1583. He confirms that indeed all that the TEC did was simply pass on what Manyeleti did. And Mr. Lamola confirms that he did the evaluation. So there's no report. There's no dispute on that. The reports that we have, it is his report. So you don't see the TEC report. It is Manyeleti report, evaluation report in both instances. Then, so we say, and if I may just give the reference, my lady, of one of the editions. Of course, the principles it comes from Odekra. But in Seal versus Van Rijn, this point that I'm making, it was sort of clarified in that matter. If I may just give a reference, is the SCA edition. I'll ask my junior to upload it on case lines also. It's Seal versus Van Rijn. It's 2008, volume 4, SA 43. It's SCA edition at paragraph 13. So this point is dealt with. And we say once the Manyeleti's appointment is declared invalid and is set aside, is the end of the matter. Is the end of the matter so far as a legality argument is concerned. But going further, even assessing the report by Manyeleti in appointing the JV Sekelek, Manyeleti, and it is important to know, to remind ourselves that Mr. Lamola of Manyeleti was in attendance in the meeting of 5 January, together with the representatives of Bakoni Sekelek, when the initial contract was cancelled. He was in attendance. And it is clear from what happens that Manyeleti was favoring Bakoni Sekelek. And we say that because there is a service provider who was unfairly disqualified when the requirement was exactly, or what they have done is exactly what Bakoni Sekelek had done. So I'm talking here about a service provider, Igoda. There was a requirement that the service providers must produce professional indemnity cover of 15 million rands or a quotation. In other words, to show that if you are awarded the tender, you will get that cover. So the facts are that, and the requirement, my lady, perhaps let me give reference. The requirement in the tender document, it falls within the list of returnable documents. It's clause 2.1 or 2.19.11 at page 001-1731. Mr. Detroit also deal with it in his affidavit at paragraph 16.2001-1576. But that was the requirement. You show us that you've got 15 million cover or a letter of intent or a quotation that you will get this 15 million. Now, we know that Bakoni, after appointment, went and got the 20 million rands cover. But when they were appointed, they did not have the cover, but they had given a letter to say, so at the moment, I'm talking about the joint venture. Now, the joint venture had cover of up to 10.5 million only. So they did not have the 15 million cover. And that is in the funding affidavit, paragraph 126, page 001-53. In the affidavit of Mr. Detroit, which is FA7, is paragraph 17.2.1 at page 001-1578. And then the proof itself from Bakoni Sekelek is Annexure CDT14 at pages 001-1576 to 1757. So it did not have the requisite 15 million cover, but it had a letter of intent or a quotation to show that if we're appointed, we will indeed obtain the cover. And it's exactly what they did. After appointment, then they got a cover of 20 million. There's no issue about that. But the unfairness is on the disqualification of Igoda because they came on the same facts. They only had a cover of 5 million rands, but they said they attached quotation from AON Insurance, showing that should we be appointed, we will then get this 15 million cover. Yet they're disqualified because of that. They are disqualified when Bakoni Sekelek was not disqualified. And we say the virtues of fairness out of the window, they disappeared. And this cannot be in compliance with Section 217 with respect. And for that reason, the appointment of Bakoni Sekelek was irregular. Now, the report by Manyeleti appears as Annexure CDT10. It starts as 001-1679, but I may just give the ladyship reference. The relevant pages is at 1683 and 1684. At 1683, there's a list there of the bidders. Igoda is number 1, Bakoni is number 2. In the column that deals with indemnity insurance cover of 15 million, under Igoda it says no. But for Bakoni Sekelek it says yes, which is incorrect. It's factually incorrect. At page 1684, at paragraph 1.7.1, Manyeleti says Igoda submitted a professional indemnity insurance of 5 million rands from AON. This tender is thus eliminated and will not be considered further. So they are disqualified when they had done exactly what Bakoni Sekelek had done. And there's no dispute that there was a quotation from IGOD. Now, we say, my lady, based on this, and Bakoni Sekelek and what it says, what Mr. Adlam says is that, look, I don't know, I've got no knowledge about all this, how they were disqualified, but we had complied with the tender provision, we had given a quotation, and we accept that. But we are saying it is not about Bakoni Sekelek simply finishing that letter, but it is about the unfairness in disqualifying a bidder who did exactly what Bakoni Sekelek. So we say that appointment falls to be set aside with respect. I've already indicated, and on this, what we've set out, it is with respect sufficient. The case of the SIU is made out insofar as Bokoni Sekelek is concerned. There can be no doubt about that. And of course, Mr. Adlam in his affidavit goes further to show that they are one of the best in the industry and they did a good job. We accept that. We accept that they may be, but that's not the issue. The issue is, if you are the best, then let there be fair competition. You will win a tender based on fairness. You can't simply be selected and appointed and others disqualified when they were not given a fair chance, as you did. So it's about that. It is not about whether Bokoni Sekelek is good in what it does. Also, SA Fence and Gate, because they say, and I'm coming to that now, then they say that, but the fences that we put up, they're still there. We don't understand why can it be said that there was irregular expenditure, because the fences are still there. But that's not the issue. It's about the fairness of the appointment. So we say the appointment of Bokoni Sekelek must be set aside, and the contract declared void ab initio. Now the appointment of SA Fence and Gate. This is now the seventh respondent. Mr. Dutoit states at paragraph 20 of his affidavit at page 001-1581. He says there was a requirement that documents had to be submitted, and one of those, and perhaps I must go to the document that he refers to. That document itself, it's a CDT 17. It's page 001-1767. So this is part of the tender document. It's got a list of returnable documents. The heading, it says all documents are to be submitted by the tenderer or by all joint venture partners if the tenderer is a joint venture. And then in paragraph 1I, it says certified copy of the SIRA certificate, SIRA being the regulator for the security industry. Now, again, to show that even SA Fence was being favored by Manyeleti. Manyeleti, when it deals with this, it said, firstly, let me just say, the SA Fence, and I'm saying SA Fence, but in fact, it was a joint venture made up of 4 entities, and those were SA Fence and Gate Investments, Pty Ltd. It was Robex Construction, RAUBEX Construction, Pty Ltd. There was Gordian Fence, GORDIN, Gordian Fence SA Pty Ltd. And then there was Mavundla Ironclad Systems Pty Ltd. When Manyeleti compiles the report, and once more, even in relation to this, leadership will see the report is by Manyeleti, it's not the TAC, it's by Manyeleti. At page 001-1779, after the first column on the left, where it says certified copy of SIRA certificate as well as letter of good standing, it ticks 1, 2, 3, 4 as being correct, implying that all the 4 members of the joint venture had submitted the SIRA certificates. This is the significance of this. But we know that it is not true. It is not true because Robex Construction is not SIRA registered, was never. SIRA registered. It had no certificate. The Gordian fence, they were registered at the stage, but they did not submit a certificate as part of this tender. So what Manyeleti ought to have done is to tick only two that two have submitted, being SA Fence and Gate Investments and Mavundla. But it doesn't do that. It ticks all of them as if they've submitted. The affidavit of Mr. Dutoit, if I may just give references, my lady, deals with this at paragraphs 24.2.3 and 24.2.4 as 001-1586. Because what Mr. Dutoit did was to contact SIRA itself, and SIRA confirmed that Robex was never registered. And at that stage, although, well, he also looked at the tender documents and confirmed that the Gordian certificate was never part of the tender, so there were only two certificates. But this is all indicative, and as I started at the beginning, that it was all this rushed fiscal dumping. Everything has got to be rushed. Manyeleti is appointed unlawfully. It also, because they have been told which service providers to appoint, and SA Fence was one of them. They simply rushed and forgot to comply with the prescripts. It is exactly what we have. So they were being favored because the IDT was told already that appoint these service providers. So this is a further irregularity that we say disqualifies or justifies the setting aside of the appointment of SA Fence. And we've already indicated that the first ground that being the product of the report by Manyeleti, then the appointment must fall by the wayside once Manyeleti's appointment is set aside. In relation to this evaluation, Mr. Dutoit deals with it at paragraph 28.1 of his affidavit annexure FA7. It says 001-1595. And this is where he says members of the TEC did not evaluate the tenders themselves. And he says they were in fact negligent because they simply took what Manyeleti did and gave it to the TAC. And of course, Manyeleti, when asked, he does say that when asked if he followed the procurement prescripts, he says, but I'm not a state organ and I did not have to, I didn't. That appears also in the affidavit of Mr. Dutoit at paragraph 10.1.4 at page 1570. And he says, I'm not bound by the PFMA. It's 1570. 1570, paragraph 10.1.4. So we say the entire appointment is tainted, and SA Fence appointment must be set aside. Mr. Mokobane also confirms that the same process that followed in appointing Bakoni Sekele, it's the same process, meaning they simply took Manyeleti's report and then handed it over to TAC. He confirms that it's exactly what they did, even in the appointment of SA Fence, and that appears at paragraph 8.3 at page 001-1668. Then there's also the same evidence at paragraph FA7, sorry, annexure FA7, paragraph 11.1.8 and 11.1.9 at page 1571, then Annexure CDT8. Okay, I've already given an Annexure CDT8. So there can be little doubt, my lady. And with this, with what I've set out, it is quite clear that the appointments, firstly, in the first tender, it's unlawful. Secondly, that of Maneleti. Thirdly, the appointment of Bakoni Sekelek. And fourthly, the appointment of SA Fence. They are all unlawful, and they ought to be reviewed and set aside. And their contracts ought to be declared void ab initio. And again, we're not asking for a cancellation, but declaration of that they are void ab initio, meaning that they would not be entitled to profits. We dealt with that issue in the supplementary heads where we analyze the Pumela judgment in case that argument is mounted, and we say the Pumela judgment in the SCA was wrong. The leadership must be guided by what the Constitutional Court has said in all pay to itself, but also in its subsequent judgments, two of them, and especially the Shabangu versus Land Bank, where it's Froneman J says, it specifically identifies it as a no-profit principle. And Central Energy Fund also confirmed that in the SCA relying on what the Constitutional Court has said. So we say it must follow as a matter of course that the profits ought to be disgorged. In any event, even if there was any doubt, the facts of this case are of such a nature that must follow, because you have, and we don't need to prove corruption per se. We don't have to prove corruption, but you have service providers who are appointed even before the relevant committee that must sit and consider. Even before it is set and appointed, those service providers are appointed. Lady, this is
no, they wouldn't have known that the internal processes have not been followed, right? So I think what may count against them is the fact that there's evidence of collusion, prior collusion, because there was prior communication with the relevant officials.
Yes, I was coming to that point, my lady. So there was prior, but they say these are service providers who do a lot of work for the state. They say so themselves. So they ought to know that when you're appointed in a tender of this nature, there has to be an advert, and I'm referring particularly to the first appointment. There's got to be an advert. You can't simply accept that you're going to be called by an official to say, submit your proposal. We're not talking of less than 500,000 rands here. We're talking about millions of rands. You have been dealing with the state. You know what Section 217 says. And if you are going to submit to a particular state organ, there are websites. You can't feign ignorance. You will approach the website and you will know, because ignorance of the law can never be an excuse. You will know that there are prescripts. So we do not accept the proposition that, look, I was just called and said I must submit, and I happily submitted. It was not my issue to raise, really, was there a tender or not, because none of them asked. And this, my lady, must be if one refers to the Gijima case, both in the SCA and in the Constitutional Court. And one of the reasons why Gijima was allowed to keep its profits is because, to its credit, when it was appointed, it repeatedly asked the CETA. It repeatedly asked CETA, but did you comply with your internal prescripts? And CETA assured them repeatedly. In fact, when they signed the agreement, they put a clause, and it's quoted in the SCA judgment. They put a clause that say CETA has undertaken or has promised us that it has complied with all its internal processes, and that is what a responsible service provider would do, even if they don't go to an extent of putting it in the contract. But because they deal with the state, they know. And this simply keeping quiet, knowing that there was no tender issued. Malady, that cannot stand. And that is where, even if they're innocent, they must at least return the profits. We are not saying, if of course it was a situation like in the Shufambo matter where there's an inkling of corruption, then we would have said that they must actually lose the entire payments that they obtain. But that's not what we're saying. We're saying, based on these facts, the profits must be disgorged. And when it comes to Bakonisake, like it's worse, as I've indicated, that even at the state of cancellation, they still negotiate the 2.6 million for cancellation of this unlawful contract. They can retain that with respect. Secondly, they say they negotiate with Mr. Nsandeni. That's what they say in the, they negotiate with Mr. Nsandeni for 4.4 million rands. Again, my lady, they can't be entitled to that because they say it's our intellectual property, but they were paid. Stages 1, 2, 3, 4, they were paid for that. So they cannot claim that it was their intellectual property. And this negotiation with Mr. Nsandeni, with respect, it cannot be correct. At the very least, it ought to have gone to the TAC once more for approval, but we don't get Nsandeni. So we on that, at least on that, my lady, they've got to return the profits. With Manyeleti was appointed and it claimed 10.5 million. So it says, and the SIU case is that, look, you rendered the services, these are the hours that you would have spent with the officials that you would have used. Therefore, what you ought to have claimed is 5.9 million. But you've claimed 10.5. And they say no, but we asked based on, we charged based on the value or the percentage. So then they got paid over 4 million rands more because of that. And we say, at the very least, because there are time that they spent rendering the services and the documents that they produced, preparing all those, at the very least, they would have been entitled to 5.9 at the very least, but they got paid 10.5. That there is no justification to retain that with respect. So, my lady, we say it must follow that there's got to be disgorgement of profits, but like we say, what we seek your leadership to do is to then give an order that they submit the accounts with supporting vouchers. So of course, if when they do that, they show that they did not earn any profit. Particularly, I'm talking about because they say because of the subsequent cancellation of the second tender, then they have losses, then there's no profits to be repaid. But that is the exercise. Let us see. Let it be open to scrutiny. Let's see. What were you paid? What were your reasonable expenses? What is your profit? If there was no profit, then of course they won't pay. So we say that order must follow, and perhaps the delay point, because one of the parties raised the delay point, although they raised it as a point in limine, but it can be a point in limine in legality reviews, because unlike in Paja, we don't need a substantive application. The Constitutional Court has clarified that in Buffalo City, which seventh respondent deals with that in their heads, we also deal with that in our supplementary heads. And we say that where the seventh respondent perhaps misses the point, and we understand that the appointments were made in 2012. We understand that, but the issue is that the SIU is only appointed in August 2017 per proclamation. They have to appoint the team. They investigate. They say so. They investigate. Investigation takes time. Even when they, in May 2018, when they produced the first affidavits, the legal team requests them to do further investigations on certain aspects. Then there's to and fro. And what I'm relating, my lady, it is contained in the supplementary funding affidavit. I'll get the, it's in my notes. Supplementary affidavit, it starts at section 002. Yes, 002, and it goes all the way to page 13, page 1 to 13. So it deals with the facts why the delay ought to be overlooked. We're not asking for that condonation be granted as though we come under budget, because there's no requirement for a substantive condonation application. That's why it can be brought. I say it can be brought as a point in limine, because in evaluating whether there's been undue delay, this tribunal had to also assess the merits, because Buffalo City says you look at the conduct of the applicant, you look at the prejudice, potential prejudice, you look at the nature of the irregularity, but you also look at the Gijima principle, which says even where there might not be grounds to overlook the delay, the courts, and of course in this case the tribunal, might very be well obliged to declare a conduct that is inconsistent with the constitution unlawful. And we say the seventh respondent, obviously, they didn't look at that. But even if we look at the conduct of the applicant, which is the SIU, it cannot be blamed for sitting supine and doing nothing after 2017. It shows that it took steps. The prejudice that may be occasion to any of the respondents, it is not real prejudice, because they themselves are suing the IDT. They are suing the IDT for contractual damages and all that. So it is not as though this happened in 2012 and the contract was ended in late 2012 and 5 years later it's only then that the SIU wakes up. No, there was a continuing harm in that payments were being made, and in fact the budget was exceeded by a whopping 81%. So there was continuing harm. So the prejudice cannot be asserted with respect in relation to the delay. But thirdly, when one looks at the irregularities, which I have detailed, these irregularities are serious in nature. They are very serious in nature, and that on its own, it will be a weighty factor that this court must take into account in overlooking the delay. In Buffalo City, paragraph 62 and 63, the Constitutional Court quotes also what Tassima said, that again, even where there may not be grounds or the explanation is porous, is unconvincing, the court may still have to overlook the delay, particularly where the applicant is coming before court as a good constitutional citizen and being bona fide in trying to correct the wrongs of the past. And we say this is what the SIU is doing here. It's trying to correct these irregularities, and of course to recover the losses suffered by the state, in this instance both IDT and DCS. So those irregularities are of huge importance. And of course, as I've already indicated, the Gijima principle that says this is the conduct that it is offending to the Constitution. And this court may very well, or the tribunal may very well be obliged to overlook the delay. The Buffalo City deals with that, paragraphs 72 to 72, deal with the Gijima principle. So, my lady, we say what we've set out in the funding papers, irrespective of the criticism and what we have presented, it's sufficient for the orders that we seek in the notice of motion to be made. And we say that the costs must follow the event, of course, and we'll hear our learned friends also criticizing the SIU of attaching voluminous documents. But we say the third, fourth, and fifth respondent equally. They've attached voluminous documents, affidavits from other matters. They've attached For example, requests for further particulars in arbitrations that are not even relevant to these proceedings. I understand with the affidavit in the other matter, I understand, but all other documents that they've attached, and it's voluminous documents, and we didn't criticize them for that, but we say, if we're successful, and of course we are said that we should be with what we've set out. If we are successful, then the respondents, they ought to pay the costs of this application. And that includes Manyeleti. Even though they withdrew, they ought to be marked with costs, because we are here, particularly on the second tender. We are here partly because of their conduct. They are the ones who prepared these reports. They disqualified people unlawfully. They said people submitted certificates when in fact there were no such certificates submitted, at least in respect of some members of the joint venture. So they misled the powers that be. So they even though they withdrew on 17 October 2023, we say they must also be marked with costs. And even if any of the respondents may convince your ladyship that we have not made out the case against them, of course we don't consider. But even if that is so, we say for tender number 2, it is Manyeleti that must still be marked with costs with respect, because we are here trying to correct the wrongs that they have committed. And those costs must of course include costs of 2 consent. I believe those are our submissions, my lady. The amended notice of motion, of course, appears at 008-1, my lady. I've got no further submissions, my lady.
Thank you, Mr. Matepe. We'll take the T adjournment until 11:45.
As a court, please, my lady.
Yes, we may start. So who's coming on first?
Malady, before my friends take over, I forgot to give the reference that I had promised that I'll give. It's just to give the reference. This is the to May 2012, even if the cancellation was on 5 January. So it is dealt with at paragraph 172. This is the founding affidavit. I mean the answering affidavit of Bakoni Sekelek at page 005-102. That's where they deal with it. The agreement itself is annexure AA23, and it's at pages 005-1063. Thank you, my lady.
Thank you. You are muted, sir. And I see both of you are trying to speak. I think I'll hear Mr. Becker first, because you might be brief.
I will indeed be. Thank you, my lady. My lady, your ladyship would have noticed from the explanatory heads that were filed on behalf of the second respondent that essentially we don't take any issues with what's contained in the factual findings and even in the conclusions that are arrived at in the founding affidavit of the SIU. The only point that the IDT takes issue with is the opinion expressed or the legal view expressed by the SIU that they doubted the legal competency of the IDT to hold appointments of this nature. Your ladyship will find in paragraph 53 of the SIU's heads the contention that it is tried that no state organ can exercise any power unless expressly provided for in law. And yet the appointment of the IDT by DCS is not made in terms of any law, and none is even mentioned either in the memorandum of agreement or in the appointment letter. That appears to be the contention. Milady, we submit that there is in fact a proper legal statutory basis for the IDT to engage as a implementing agent on behalf of other organs of state. We've referred in our heads very briefly to section 41(1)(h) of the Constitution that enables organs of state to cooperate. We refer to section 238 of the Constitution that provides that an organ of state may delegate powers. Importantly, we refer to the Intergovernmental Relations Framework Act that provides specifically for an implementation protocol to be adopted by organs of state. And we've referred in paragraph 13 of our heads to the National Treasury instruction that provides specifically for, which specifically prescribes the market-related management fees that the IDT may charge to government departments, constitutional institutions, and public entities. And finally, we refer your ladyship to the National Treasury Instruction 3 of 2019-2020, which is referred to in paragraph 15 of our heads. And that is the instruction that incorporates the framework for the infrastructure delivery and procurement management of May 2019. We've attached a copy. Malady, this only just wish to draw attention to the fact that this particular framework was only introduced in May 2019, which is well after the fact. However, this provides the legal basis, is seen at paragraph 5.4 of the framework. We've quoted the section in paragraph 16 of our heads, and it expressly states that where organs of state who engage another organ of state to provide agency services shall develop a service delivery agreement that should outline the roles and responsibilities for each organ of state, which creates a relationship. Malady, we submit that it expressly provides therein by means of the Treasury instruction that there's in fact a proper statutory basis And the result that is the only aspect of the SIU's argument and evidence that not evidence, just on the legal aspect, and we respectfully submit that we've shown that there's in fact a statutory basis. We also give the assurance later on our heads that insofar as the IDT may be a necessary party to assist, should there be a further stage of these proceedings in the form of a statement and abatement, the IDT will be able to render assistance. And if there's any issue or dispute arising relating to where the fund should eventually end up, i.e. with the IDT or with DCS, then that is provided for in the Intergovernmental Relations Framework Act, and we will deal with it accordingly. So we respectfully submit that no issue would arise and that this aspect should not trouble your ladyship in your judgment. Thank you, my lady.
Thank you, Mr. Becker.
Thank you, my lady. If it's convenient to your lady, I'll begin.
Yes, you may, Mr. Simon.
Thank you. My lady, just an observation, and then I'll tell you a little bit about how we propose to tackle this. So the observation I make is that it's quite clear in my learned friend for the SIU's address that he focuses the illegality primarily on the conduct of the IDT. And as Mr. Becker correctly points out, the SIU's position is that the illegality which taints any possibility of setting aside these tenders is fundamentally rooted in the misconduct of the IDT. He even accepts the notional possibility, my learned friend for the SIU, that the other, specifically our parties, but maybe some of the other respondents too, I can't speak for them, may have been innocent in what had happened. And as far as the SIU is concerned, that doesn't change it. But the focus of the illegality is the conduct of the IDT. And of course, if there is an illegality, it is appropriately so that the perpetrator, the chief perpetrator, be identified and addressed. And astonishingly, amongst all the relief that is sought, there is nothing here about the IDT and the consequences for them. And in fact, when you look at the accounting that's sought in the notice of motion, they want the proceeds, should they be successful in their endeavors in this application, to be given to the IDT. That is astonishing, absolutely astonishing, that should even be a suggestion that is being made in the circumstances, because the mischief lies within the IDT if it exists at all. Now, the other proposition I want to make in regard to that is that with regard to the witness that have been brought by the SIU, and you see it very much in my learned friend's address, that he contends that there isn't a hearsay problem or any other problem, because as far as he is concerned, he has the witnesses, and he identified two of his main witnesses as being Mr. Mzadeni and Mr. Jugal, the quantity surveyor. So the difficulty that one has with that is that you can't really rely on the evidence of those witnesses. They are the ones who are the perpetrators. So the assembling of this case is primarily based on information which emanates from the persons who the SIU contend are the chief cause of the mischief. So if your ladyship would bear that in mind when you consider the conduct of the other parties of which my learned friend for the SIU has alluded. So what do we then do, and what are we hoping to achieve here? So if I tell your ladyship a little bit abstract, we're going to go about our address to your ladyship. I intend to deal with some of the issues, and my learned friend, Mr. Sirianu, will deal with the other issues. So I'll deal with some of the upfront issues. One of very substantial importance is the question of the ambit of the proclamation and whether it includes both tenders. Or SIU directly that up during the course of that was an issue, and he was willing to engage on it, but he hasn't had an opportunity yet, I'm sure, to engage properly, or your ladyship to hear what we have to say about it. So I will deal with that. I'll also make some observations about the issue of prescription, and I'll make some observations and submissions in regard to the presence of the IDT in the form of their citation in this proceedings, and who they are and who represents them, and whether they can be represented. It's a fairly fundamental issue also. Then I'll talk a little bit about the imbalance that lies here between the different litigants that you have before you. You have the state on the one hand, with all the resources imaginable in regard to every department that may have had any role to play in the outcome of these tenders, particularly as far as organs of state are concerned, the IDT and the Department of Correctional Services, but the version, which is primarily based on what is relayed by the wrongdoers as to what may have happened here, together with what the state has supplemented for itself out of the array of resources available to it. We, on the other hand, have our knowledge of what we know and what we know only. But if it's to be determined on motion and without evidence, we're at a fundamental disadvantage because we're unable to cross-examine the perpetrators within the IDT. We're unable to examine at what point which organ of state had what knowledge about what alleged irregularity. We're unable to have a full grasp of the facts, or at least an equal grasp of the facts to the possibilities that are open to the SIU. That structural imbalance is something which your ladyship should also consider when you take into account the way that you're going to decide this matter. The rule, of course, in motion proceedings, in the ordinary court in civil proceedings, is the Plascon Evans rule, which means that if you, as the person seeking relief, want to rely on motion and not evidence, you must live with the evidence that's in the respondent's answering affidavit. You can't question it. You have to accept it. So from that perspective, it adds another dimension to it. And then I'll have one or two observations to make about the first tender. My learned friend, Mr. Stiliano, on the other hand, will be focusing his address on the second tender, the elements of it, and he'll also be looking at the question of what Gajima means and what can be made of it in these circumstances and what the implications are. I'm going to try, I think it may be of assistance to your ladyship, to stick to kind of some of the submissions made in the heads, but I'll divert from them. And a good place to start is what actually is before your ladyship right now. Is it what is called DCSSF01, or is it DCSSF02, or is it both of them? So we make a firm and committed submission to your ladyship that there is no room whatsoever for your ladyship to give any consideration at all to DCSSF01. It was not part of the proclamation, and we did deal with the proclamation comprehensively. It is not part of the proclamation. It is not part of the mandate that was given to the SIU, and hence it is not properly brought before your ladyship. So if I can say this, there's an attempt to say that they're two different tenders. They're different tenders with different numbers. They involved different scopes of work because, as you know, as far as the SECOLEC parties are concerned, they're telling your ladyship, and I'll say a little bit more about it in due course, that in the way that professional engineers work, with regard to their professional contract, which is the standard contract. It wasn't one which was deployed by these parties for purposes of this tender, which the SIU considers to be corrupt for either of those tenders for that matter. But looking specifically for the first one, which is excluded, I just want to make the observation that on the version of the second-leg parties, they completed, and for Plascon Evans, you need to accept that they've completed the first 4 phases. So they didn't have to be recompleted. It's a separate item with separate scope of work. And in fact, you'll see that when the parties, the IDT and the second-leg parties, agreed to cancel the agreement, the first tender, they actually had made provision for the fact that there would be work which would go into the second tender and gave a discount in connection with it. They are different tenders which were handled under different processes. So let's look at where we are in this. And let's take a look at jurisdiction and how it works. So if you go to page 8 of our heads, which is at 012-2, now, we submit something uncontentious here, and the applicant derives its jurisdiction solely by virtue of the Act, the SIU Act. The applicant alleges its jurisdiction flows in respect of the subject matter of what is before you from a proclamation issued in terms thereof by the former president, Mr. Zuma, which reads as follows. Now, therefore, and we've quoted to some extent, sorry, my lady, we are experiencing load shedding. I don't know if you are, if it's affecting your ability to hear us in any way.
I can hear you clearly, Mr. Simon.
Thank you, my lady. We have no electricity at the moment, so I'm in darkness with regard to any papers. I know our generator will kick in a minute, so if you'll just bear with me, I'll try and go forward because I've got some materials that I'm looking at on the computer which I can see and others which I can't see because they're loose materials with the dock. But let me try and stick to the heads then which I can see. So the jurisdiction, that proclamation reads as follows. It has come back. Thank you, my lady. So if you look at the proclamation, it says, and this is what the president is empowered to do, as your ladyship knows, under the SIU Act. I hereby, under section 2.1 of the Act, I'm looking at 012-3, we have quoted from you, we have recreated extracts from the proclamation. We haven't, and if we have done it, it wasn't advertent, and if we missed something, it wasn't intentional. There's no cherry picking going on. We've tried to do this comprehensively, and anything that we've missed, we'd be happy to address. But what it says, and it begins by saying that the president, under the Act, refers the matters mentioned in the schedule. So the first thing to note is what's been referred is the matters mentioned in the schedule in respect of state institutions. The second thing to note about this interpretation is that it's for investigation to the SIU. That's the second thing. The third is for purposes of investigation of the matters. Once again, it's restricted by the word matters. And then there's a further restriction that it's in terms of the terms of reference to conduct an investigation. So from the preamble to what the president is saying, he is himself confining it to reference to particular identified matters in terms of the terms of reference. And those are serious maladministrations, improper or unlawful conduct, appropriations of public money, unlawful, irregular or unapproved acts, intentional or negligent loss of money, unlawful or improper conduct. Now, this is what he says. It's so interesting, my lady. He goes on to say, go and investigate under these terms of references the following ambit of things. So he first puts a time limitation. So the time limitation is that it must take place between 1 November 2011. You've heard from my learned friend, he began his address way before November 2011. He began his address by drawing your attention to matters before that, where the IDT was engaging with the DCS in relation to what they might spend money on in relation to what he called the fiscal the fiscal misconduct with regard to trying to spend the budget before year end. Started before that. So the time limitation put by the president is between 1 November 2011 and the date of publication of this proclamation. So that's the first time limitation. Or he goes on to say, which took place prior to that date. So he says, whilst I'm setting it from that date, I do want to allow for the fact that you might be able to take into account things which took place prior to that date. But then he goes on to say something else. He says, or after the date of this publication, of this proclamation. So in other words, he's saying that I want to put time limitations, but there are no time limitations. They have to be between November and the date of this promulgation. But if it's before, that's okay as well. But if it's after, that's okay as well. So this is respectfully a nonsensical delimitation in time. So what do we do with that? Because he then goes one step further. And look at those last words, because this is the only way that my learned friend for the SIU is able to contend and has contended that somehow another tender with a different number and reference is to be part of an investigation into a delimitation per matter of a different tender. So he says, but look, it says the words, but is relevant to, connected with, incidental or ancillary to the matters in the schedule, or involve the same persons, entities, or contracts investigated under the authority of this proclamation, and to exercise the functions and powers of the SIU, including the recovery of losses. So you can either look at this to say, actually, there's no delimitation in time because it goes backwards and forwards to any time that you can pick. Secondly, there is also no delimitation in terms of subject matter, because if it involves the same persons or anything incidental or ancillary, it is covered anyway. So you can't respectfully interpret this to mean that this is a direction from the president to investigate matters which have no limitation in time or in content in reality. So you have to respectfully apply the well-known dictum of Mr. Justice Wallace in the Natal Municipal Fund case, which is the most recent pronouncement of principal importance in regard to the interpretation not only of contracts, but also with regard to statutory or other instruments which require interpretation. And that is, you have to use 3 tests. You have to say to yourself, what is the proper wording? It's a matter of construction in the first place, but also in context. So the way the learned judge described it is you look at text, that's the act of interpretation by looking at the words. You look at context, which is where does it come in? And you look at purpose. What is the purpose of this? So you have to find, when you look at this, some way respectfully to interpret it with some limitation. Otherwise, there's no limitation to speak of. And what I would suggest to your ladyship is that when it is all to be found in the word but, halfway through there, because you can take the date between November 2011 and publication, you can take it before. But the third thing is he's saying that if it's after the date of publication, that has a qualification. It's only that which has the qualification. and that is that it's relevant to, connected with, or incidental. So what I'm suggesting to you, if you want to go and investigate matters after the date of this promulgation, you can only do it if then it is relevant to, connected with, or incidental, or ancillary. Otherwise, they wouldn't use the word but, because it's only if you use the word but in connection with matters which occurred after the proclamation that it makes sense. That but can't qualify the period between November 2011 and the date of proclamation, or the period before that. It has to cover the period thereafter. And that gives a little bit of leeway into what is relevant or connected to or incidental to. But I want to make this point, and I'll show your ladyship an authority, which I only found last night, and which I'll draw to the attention of my learned friend and your ladyship, in which this particular phrase, relevant to, connected with, incidental, or ancillary, was addressed to see if that enabled the tribunal and the SIU to go further than the actual designated tender and into others and into different subject matter. And the court remarked that when you look at these wordings, the wording here from but onwards, and which refers to incidental, ancillary, or connected with, it's qualified by incidental or ancillary to the matters mentioned in the schedule. So that qualification means it's only in regard to what is actually proclaimed in the schedule. You can only do it in connection with that tender. That doesn't enable you to go into another tender. You are confined completely by that tender, despite the expansive wording. So what the net effect of it is nothing in this provision entitles you to interpret this to go into another matter, which is another tender. So that is completely excluded. There is no way that the jurisdiction which your ladyship has entitles you or the SIU to seek relief, or the SIU to seek relief, or your ladyship to grant it in respect of another tender. There are mechanisms that exist to ask the president to amend the proclamation, which is referred to in the judgment which I'm going to give you, but you can't just do it unilaterally as the SIU and say, well, I'll just argue that it's ancillary to it, or it involves the same parties. It's inconceivable that the president would be in a position to give the SIU a launching pad to investigate whatever they considered in some way to be related, even if it's outside the matter actually specified. So, and there's a principle of this, and I'll come to it a little bit further when I get to it. And the principle which has been recognized in the authority which is quoted in our heads is that commissions, and the tribunal has been said to be in the nature of a commission. The commission and the SIU is in the nature of an investigating commission. The tribunal makes decisions, the SIU investigates. That is an intrusion into the rights of individuals within the state. It is an imposition on them that they be called to account, particularly if the fault lies within an organ of state, as my learned friend for the SIU has pointed out. It's an imposition. So that means you have to restrict the ambit of what is under investigation and interpret it restrictively. It's not to be subjected to expansive interpretation to give the state a license to investigate whatever they think might have some correlation. It is subject to the Constitution, which demands a limitation on an invasion into the freedom of people in the state to conduct their commercial activities as they deem fit. And particularly if you accept the notional possibility that they are innocent in all of this and the misconduct lies deep within the state itself, both with regard to the IDT to start with, but also with regard to the various mechanisms that are in place to keep a check on the IDT, which involves Treasury, which involves Auditor General and other institutions. So my submission to your ladyship, if I can develop it by going further into the construction of the proclamation. If you look at the proclamation, the schedule, so the president has the power to make a determination as to what is to be the subject matter. That's in terms of the act, and he must set out in the schedule the matters with which he is concerned and that the SIU should investigate. When you look at the schedule which is attached, the schedule provides for the following. These are the things that the president wanted to investigate. Okay, so and if you look at it up front in item 1, straight off the bat, the president wanted the following investigated: the procurement of or contracting for goods, works, or services by or on behalf of the state institutions in terms of bid number DCSSF02 and payments made in respect thereof, in a manner that was not fair, competitive, contrary to legislation, etc., what my learned friend has spoken about as the prescripts, which is conducted through the improper or unlawful conduct of officials of state to corrupt and unduly benefit themselves or others, or which is fraudulent. So we point out to your ladyship, please, to take note that the schedule is specifically limited to bid number DCSSF02. No mention whatsoever of DCSSF01. If the president wanted that investigated, he could easily have specified it, but he elected not to. And we don't know why he did or why he didn't, but the fact that the agreement was cancelled already may have had a bearing on it. But he expressly excluded it. He didn't include it. Then we look at paragraph 2. Malperformance or performance by service provided, professional consultants, in terms of, again, his specific bid number SSF02, I'll just call it 02 for short. No mention of 01. Again, he could have done it there too, but he decided not to. Then we go to paragraph 3 of the text. Any improper or unlawful conduct by employees or officials of the state institutions, service providers, or any other person in relation to the allegations in paragraph 1 and 2. Now, we know that paragraph 1 and 2 was expressly limited to 2. There's no warrant for finding something that the president didn't expressly want. This is not an interpretation to wonder why the president asked for one and not the other. If it's not there, it's not there. The next one is paragraph 4 of the schedule, which reads as follows. The appointment of the trust. This is a very significant issue, my lady. It's one which is vaguely disturbing. So what the president actually wanted to investigate is the appointment of the trust. Mr. Becker has submitted to you, there's nothing wrong with that appointment, but that's something which my learned friend for the SIU takes a completely different view on. It was what the SIU was charged to investigate. They're the cause of the mischief. It's entirely appropriate that the president asked them, and look what he asked them, that the appointment of the trust as agent for the implementation of 02 and payment made in respect thereof is limited in a manner that was not fair, competitive, etc. He focuses here on an investigation into the IDT's own appointment. Again, in paragraph 16 of our heads, we point out that this is limited to DSSF 02 and not 01. And then the final paragraph of it reads, the appointment of professional consultants by the trust for bid 2 and payments made in respect thereof, not in any other tender, in a manner that was not fair, competitive, etc. And again, only 02, no mention of 01. Now, your ladyship, these 5 paragraphs in the schedule, 5 times the president had the opportunity to include SF01 and decided deliberately not to do it. How can it be that the SIU can lift themselves by their own petard and find a power for themselves which doesn't exist and which the president didn't give them because they think it should have been given. That's not possible, my lady. That is not possible. This is a creature of statute. The SIU is a creature of statute. It must operate within the limitations of what their powers are as conveyed to them in the instrument created by the statute, which is the president's proclamation, limited by the schedule, and which of itself excludes what they want to do. It's very straightforward. And what we submit to your ladyship is that if you look at the importance of this, half of the relief in this application is directed at the SECOLEC respondents. Correct 1 and 2 of the notice of motion right up front before you even get to SS2. It's the only thing they're entitled to investigate. In these paragraphs, they want to set aside DSS1 and that it be declared void ab initio. It's outside their mandate. They have no power whatsoever to do it. The next is in paragraph 9 to 11 of the notice of motion. The SIU asked for an accounting from the SECOLEC defendants of all payments received under the impugned contracts. Those are what they call the 2 contracts, and that the accounts be debated. The relief sought is far-reaching. It's important to establish whether it has that jurisdiction or doesn't have that jurisdiction. So now we refer you to one case. It's not the one I found last night. This is the one in the heads, which of itself, my lady, is respectfully dispositive of this issue. There's no real answer to this other than the invocation that it is somehow connected and that both of these projects related to the DCS and there's some of the players that are common. So what? If the president wanted to investigate, he could have done it. In the matter of special...
Mr. Steemer, that's the crux of the SIU case. I cannot ignore the fact that the proclamation makes reference to matters connected with incidental or ancillary to matters mentioned in the schedule. It doesn't stop there. It says, or it involves the same persons or entities. It doesn't just say contracts, because your point is it's got to be the same contract.
It's not only mine, my lady. It's another judgment which I'm showing.
If it involves this, well, I can disagree with that judgment. If it involves, and I've not read it, I'll have a look at it once you've given me, once I have the opportunity to do so. If it is connected with, relevant to, or incidental to, and the SIU has made the case that it is, the purpose of this procurement was fiscal dumping. 2 tenders were used to achieve that purpose. It was 01 and 02. It wasn't just 02, right? So the phrase relevant to, incidental or ancillary catches 01 for that purpose. And to the extent that same entities are involved, 01 is in.
Lady, I can only make these submissions to you and your ladyship will make the decision. My submission to your ladyship is this, that as I'll show you in another case, and you of course you were right, my lady, you don't have to agree with that case, but here is a case that makes the issue the specific item that was designated by the president, and it is qualified only in respect of that. You can't go into another tender. What you can look at is ancillary conduct, but you can't look at and set aside another tender. That's the thrust of what I'm going to submit to you. And I'm wrong, but these are our submissions. And so what I want to say to your ladyship is what perhaps I can give you, and you will have a look at it. Obviously you have time to consider it, and you'll think to yourself, well, this is right, or it's different, or it's wrong. But my submission is that it's helpful to your ladyship, and it is against the SIU, because the fact that they say that it has those qualities, my submission to your ladyship is not enough. It has to still fall within the parameters of what is designated. So this is what the other judge had to say. My lady, this is, can I refer you to a case called Mabayani? If your ladyship would like me to email it to you or something like that, I can do that. It's called Mabayani versus President of the Republic of South Africa.
Yes.
The citation is 2023, very recent case, 2023, JDR 2282 ECB. It's an Eastern Cape Division judgment of Mr. Justice or Miss Justice Norman. Now, it has to do with certain investigations that were happening at the university, and certain types of matters were under investigation, and the SIU tried to expand the scope of it by relying on the fact that the proclamation was also subject to the same wording about in connection with, related to, same parties, etc. And the court said, no, that's not good enough. So if your ladyship will go to paragraph 70 of this judgment.
Did you say 7 or 70?
70, my lady, 70. We will upload it to make it easier for your lady. It will be on the case lines. So paragraph 70 says the following. There's similarities and there are differences in this case, but this is what I want to draw your attention to. The words perhaps maybe 69. In defense of the actions, the SIU contends that the proclamation, 69, the proclamation refers to incidental, relevant to, connected with. Mr. Marcus argued that the applicant accords a narrow interpretation, and yet those words lawfully extend to the investigation into the master's program. There was another program that was under investigation at the university, and what the SIU were arguing is that this extends to the master's program as well because of those words, incidental, relevant to, or connected with. This submission, with respect, is what the judge finds, omits the qualification that follows immediately after those words, but is relevant to, connected with, incidental or ancillary to the matters, or involve the same person's contracts under authority of the proclamation. So it's exactly the same point as being raised before your ladyship now. And look, the judge says the word in and authority of this proclamation are the limiting word. Any matter that is not under authority of the proclamation excluded. That's all with ancillary to, or relevant to, or incidental to, are directly linked to matters mentioned in the schedule. No other plausible interpretation could be given to those words. To extend their relevance to the matters that are not in the schedule would be to usurp the president's powers. The SIU relied on Harvard's Levy for its contention that where a legislative or administrative provision is susceptible to more than one meaning, the court should lean towards an interpretation which is valid rather than giving it meaning. And then the judge dealt with all sorts of principles of interpretation through a number of cases. And so eventually, your ladyship will see how the judgment lands, but some of the considerations that your ladyship is raising here are those that were addressed there. And the court was not happy, as I understand this judgment, to expand it beyond the limitations of what the proclamation itself were, just because of the use of those particular words. There are, of course, issues that your ladyship might find this distinguishable. Your ladyship might find I'm not reading it correctly. There are all those possibilities to consider. But I'm drawing it to your attention because it seems to me that may be helpful for your ladyship one way or the other. You might say, well, I fall within this or I don't fall within it. So perhaps your ladyship will have reference to it. But to return back to the judgment that we did give you in the heads, your ladyship will have noted that what we have said in the heads is that, sorry, my lady, I'm just now in that judgment rather than in our heads.
The Nadesan, is it the Nadesan judgment you're taking into?
Yes, that's the one, my lady, your ladyship. It's like a commission. It is well to be reminded of the invasive nature of commissions, how they can easily make important inroads upon basic rights of individuals. Important that an exercise of powers by a non-judicial tribunal should be strictly in accordance with the statutory or other authority. The introductory part of 4.1 of the Act emphasizes the point. This accords with the approach of the Constitutional Court. I won't read it all. A tribunal under the Act, like a commission, has to stay within the boundaries set by the Act and its founding proclamation. It has no inherent jurisdiction, and since it trespasses on the field of ordinary courts of the land, its jurisdiction should be interpreted strictly. So a well-known principle, it seems to have been approved many times in judgments that I was looking at as I went through the law reports. And so what we're saying to your ladyship is that you when you look at your jurisdiction, because this is a jurisdiction point, what we are saying is that the SIU are outside the express proclamation, and there is no warrant for trying to draw them in because of words that are themselves qualificatory of a particular tender. It doesn't take you far enough into another tender to assume jurisdiction to set it aside. Those are our submissions in relation to that. Now, let me say a few words about the question of prescription. I'm not going to dwell on it. Your ladyship's judgment is instrumental. We refer to it as paragraph 28 in the SABC matter. So what are we talking about here, my lady? If we can look at this. So it's the IDT that are the SIU have determined to be the wrongdoers in all of this. The IDT would, if a wrong has been done to them, in the first instance, that wrong would be recoverable by them. One must, of course, be careful about the fact that the wrongdoers are in charge of the IDT. So in the law of prescription, you find many instances where the courts would be reluctant to attribute knowledge for purposes of the running of prescription to the wrongdoers themselves. So if the wrongdoers themselves would be in charge of the IDT and not bring the process, then you could understand that there'd be a reluctance to make prescription run in respect of the claim. You see that, for example, in Section 13 of the Prescription Act, which provides for the fact that Section 13 of the Prescription Act provides for impediments to the running of prescription. And so, for example, if the wrongdoers sit on the board of directors of a company, it delays the completion of prescription for a year until after they leave. There's a well-recognized principle that you don't want prescription to run against an entity which is controlled by the wrongdoers who have every interest in not pursuing a claim. But on the other hand, when the SIU brings its claim, it is bringing its claim for the wrong which has been done to the IDT. So Section 4 of the SIU Act distinguishes between when it brings it in its own name and when it brings it in the name of the institution of state. But in reality, what you're actually talking about always is the same right of action. That is a recovery for some type of illegal contract which has occurred. It's not an easily distinguishable claim just because you bring it in the name of one person rather than the other. The fact that you bring it, if it is a wrong, in the name of one person rather than the other, shouldn't be able to affect the running of prescription. That fact doesn't matter because it's the same. What the prescription law talks about is the right of action rather than the cause of action. The complaint that you have, that you seek recovery about, is the kind of thing that commences the running of prescription as soon as you have knowledge of it. So let's look at what happened here, because if I can, there are two sides to the story. And the two sides to the story are exemplified by the conflict between your ladyship's judgment and the judgment of Justice Stradle. They're two different, completely different senses of it. And let me say this, the argument here is confined to SS1, because assuming that it is within your jurisdiction, and which is, as you know, something which we don't concede, but assuming that it is, that goes back to a long, long time ago. The contract was cancelled many, many years ago. In 2000, and by the end of 2011, early 2012, on any version, this contract was cancelled, even though the agreement may have been concluded later as to the consequences of that cancellation. That's years. It's like nearly a decade later that the claim was brought. That's not the same with regard to the second contract, where I think it was cancelled or issues arose in regard to claims of recovery only in 2016. It's a different kettle of fish. 2018. It's a different kettle of fish. And your ladyship will know that the SIU's appointment only came about in 2017, 2018. My learned friend will tell us exactly. So we're talking here primarily about that first course of action. So when we talk about the right of action, so there's a case, my lady, it's a leading case which we can load for your lady if you need it. It's called Centrichem versus Princehood, which means you don't need to have the full perfect details of a cause of action for prescription to start running. It's enough if what is cognizable in the facts is what's called a right of action. It's just a labeling of a complaint that you've done me wrong. At that point, it's a dangerous point for plaintiffs in prescription, because once it can be established you've done me wrong, prescription starts running in regard to that claim, even if you don't have perfect knowledge. So let's go back to your ladyship's judgment. Your ladyship's judgment says, on the authority in Kim Diamonds, the SIU, as a representative applicant in terms of the SIU Act, is only entitled to the relief to which the SABC is entitled. As I understand your ladyship, you're recognizing that the complaint, the labeling of the complaint, whether it's in the name of one or the other, that's the complaint. The complaint is known. So the relief is really relief, which is at the instance of the IBT if it has been wronged. And so it's only entitled to the relief to which the SABC is entitled. It's hard to imagine a case where the SIU would have relief and the actual state institution wouldn't have relief. They are so fundamentally interconnected. It's respectfully a very narrow view to say, oh, well, you can sue in your own name or you can sue in the name of the state. That's the counter judgment, as your ladyship will see. But in your ladyship's judgment, you say, but hang on, let's not be that hasty about it. And you go on to say, similarly, the defences that a respondent has against the SABC may be raised against the SIU. To demonstrate the sound basis of this principle, it would be absurd in these proceedings to declare the text prescribed against the SABC, but not to have prescribed against the SIU, given that the SIU is only entitled to relief that the SABC is entitled to. It's hard to imagine, as I say, a situation where the SIU can claim where there isn't an organ of state that has somehow been wronged by its own officials. It's hard to imagine that could ever arise. Why would they have a cause of action which is completely independent? They are inextricably linked. And so the claim having prescribed against the SABC is not entitled to any relief. Therefore, the SIU is not entitled to relief. That's a jurisprudential assessment. So it's respectfully an interpretation of the position as to how it impacts on prescription. And so another judge has, as that judge's right is to differ from you. So Justice Stradle in paragraph 29 says in a 2022 case, cited your ladyship's passage and says the implication of this finding is that the SIU can only pursue claims which the SABC could have pursued. The SIU merely steps into the proverbial shoes, albeit that it's in its own name. It's a difficult concept that you can sue in your own name for a wrong which effectively has been done to another. It's a difficult concept because for a cause of action to exist, the wronged person must be the one to have suffered the loss. And so grapples with it, he or she, the judge grapples with it, Judge Stradom, and says, well, in my judgment, I found the opposite, that the SIU could sue in their own name and that a separate cause of action became available pursuant to the Act. They sued in its own name without joining with...
It's not a separate cause of action. It's the same cause of action. It's not separate.
That's what I'm struggling with, my lady. That's the difference between the way your ladyship sees it and the way the other judge sees it. Section 4.1 provides that the SIU can institute and conduct civil proceedings in a special tribunal or a court of law for any relief relevant to any investigation. And Section 5.5 determines that notwithstanding anything to the contrary in any law, and for the performance of any of its functions, the SIU may institute and conduct civil proceedings in its own name or on behalf of an institution in a special tribunal. Consequently, an option is provided to the SIU either to institute civil proceedings in its own name or the name of a state. How can the name that it chooses affect prescription? The name is not important. What is important is the nature of the cause of action. And the interpretation of these sections becomes important, as that will determine when a prescriptive period will start to run. In my view, if the SIU instituted proceedings in its own name, the prescriptive period could only start when it became aware of the debts from when they arose. So look at this other absurdity respectfully that may result. And perhaps this judge is right, perhaps your ladyship is right, but look at it from another point of view. So the SIU only came into operation, I think it was in 2018. So no claims could ever begin running prescription before they even came into existence. How can that be? That means the entire law of prescription has been set back. The clock has stopped in respect of the same losses. There's no running of prescription against anyone if the SIU makes a choice. And if the choice they make is to do it in their own name, what is effectively the same complaint, the same right of action, the same label of a complaint, they get another 3 years to sue for. But in regard to if they chose to sue it in the name of the organ of state, which they're entitled to do, then there could be an issue of prescription. How is that possible that there's a bipolarity about the running of prescription depending on in whose name you decide to sue? I must say,
Mr. Simon, please assist me here. In this Chitumba judgment, when did the SABC acquire knowledge of the cause of action? Do you remember?
Maybe I'll have a closer look, but it was, as I understand it, it was more than 3 years. But we'll have a closer look and I'll refer you to the passages. Perhaps your ladyship is right. Perhaps it's distinguishable on the basis that in either event they would have still had a cause of action. And it is quite a fundamentally important jurisprudential debate on which there are two perfectly legitimate points of view. I'm not suggesting that there isn't another point of view which may have some arguable legitimacy. I'm saying that we are not respectfully prepared to discount your ladyship's view in favour of a different judge's view. There are elements that commend both. It's quite a difficult decision. But what we say to you is that if you apply your ladyship's test, then the first claim is prescribed. And so we'd asked for a stay of that. So your ladyship will know that the IDT instituted an action itself for certain recoveries, and the point of prescription was raised. You were told that in our answering affidavit. So perhaps the solution is to ask for a stay. But I don't want to avoid the problem, because that in a way avoids the. If it goes to the IDT's course of action, and if that has already prescribed, it will have prescribed. The SIU could be saying to you, no, you must determine it now, because we are saying to you, ours is a legitimate cause of action with a different prescription period. So the fundamental choice essentially still remains. It's a choice between very different jurisprudential analyses. Then, my lady, with regard to the next point that I want to raise, it is the question of lis alibi pendens, which the SIU referred to. I'm not going to deal with this very much, because you'll find in paragraph 25, although we criticised for adopting a position which they say is somehow designed to frustrate the SIU by raising the alibi pendens, we quote for you what we actually said. I mean, I think they mischaracterized our position. But we've said, despite all the difficulties, we submitted in paragraph 35 of the heads that this matter should be properly disposed of before the special tribunal, and that the first review should be dismissed with costs alternatively stayed pending application. So we're not vacillating. Our position with regard to jurisdiction is the first one isn't within the ambit of the proclamation. But we don't want you to feel that our position is that you can't decide anything and we're trying to deflect it into some other process. It's not in anybody's interest that this endures and endures. This is 13 years after there's a question raised about the first tenders, 2011. It's over a decade, and with regard to timing, nobody's interest is served in trying to deflect your ladyship. Your ladyship has a task to do, and we're not unsupportive of that. It's pointed out to me that the other judgment, my lady, I said I'd come back to you. Can I refer you to paragraph 4 and paragraph 181? Sorry, 180. Sorry, it's my eyes. It's paragraph 4 and paragraph 8 of that judgment. Sorry, it's paragraph 4 and paragraph 18. Paragraph 4.
Which judgment,
Mabuyane? The Chidzuma judgment, the one of Justice Trade. So it was contended, you'll see in paragraph 18, that prescription would have set in had it been the cause of action of the state institution rather than the SIU. My lady, so we don't need to dwell on lis alibi pendens. I just want to make some comments about motion proceedings. I've already pointed out that we need to follow Plascon Evans if we do. But there's a...
Except that you've referred to it selectively, Mr.
I beg your pardon, my lady?
You've selectively referred to Plascon Evans. It doesn't stop at the respondent's version being the version that is relied on. The veracity of that version matters.
No, my lady, only in a limited sense. In order to overcome Plascon Evans, you have to show that the respondent's version is so seriously and inherently improbable that it can be rejected on paper.
That's what I mean, yes. Its veracity matters.
Yes, but, well, the probabilities matter, but only if it's so seriously and inherently improbable that you can't believe it even on paper. No allegation has been made as to that exception to Plascon Evans in the SIU case.
It also can be bad. It can be a bad denial, right?
It can't be a bad denial.
Far-fetched, can be a bad denial.
Yes, and in fact, I think the most recent exposition of it is in one of the Zuma cases. I think in the Constitutional Court in the Zuma case, they gave the most recent exposition of Plascon Evans, which is effectively that it is in fact the respondent's version. The only exception to that is if you can reject it on paper, and that has to be a serious rejection. And there's no blame denial here, my lady. There are hundreds of pages of affidavits and annexures and a version that is set out chapter and verse. In fact, I don't think it is unfair to say that with regard to our version, that we have made a serious, thorough attempt to explain everything relating to it with regard to both tenders. There's no, for better or for worse, that is the version that is there. So, my lady, the reason why I didn't tell you that exception, because I don't believe it applies. But if your ladyship is aware of it, and if your ladyship feels that there is something that has been said that you can reject on paper, obviously your ladyship will then deal with it on that basis. But the primary rule, which we generally refer to as the Place van Evans rule, is that it's the respondent's version that counts. So I can't take it further than that. What I wanted to say about this is that the case made in paragraph 44 of our heads is for failure on the parts of organs of state to comply with internal control requirements. The extent to which they failed, we can't comment on. So if you listen to what, as you have, my learned friend's address for the SIU, he went into a fairly substantial amount of detail, for example, on the first tender, as to engagements between the SIU and the Department of Correctional Services that preceded November 2011, when everything happened contractually. All of that is unknown to us. To what extent they did or didn't comply. What seems to be the position is there are circumstances where you can select suppliers under the supply chain. There are circumstances when it can be done urgently. Whether the IDT did everything that they're supposed to is unknown to all the respondents. How would they know what the IDT and the DCS and what Mr. Becker referred to as intergovernmental cooperation arrangements and how far they went and when they went into place? No, so you have like a unique example, my lady. I'm conscious of this, that in the Gajima case, the important Gajima case, that what happened in the Constitutional Court took into account the fact that the Gajima, they were questioning the state authority. They were questioning them, saying, are you sure you've done everything you have to? I want a warranty in the contract that you have. And still, in the end, it turned out that they didn't. Surely, my lady, that when you deal with the state, it's not like dealing with everybody else at arm's length. Surely the one thing you're entitled to accept is that the state itself will have complied with its obligations, internal controls, requirements, treasury approvals, procurement policies, supply chain policies, restrictions, urgency requirements. You're entitled, I would respectfully submit, to assume that that's their business, and they wouldn't put you in a position where they would turn out to have failed you and to have failed those to whom they're accountable within the structures.
But isn't that an ostensible authority argument, which doesn't apply to public procurement matters?
No, my lady, it's not an ostensible authority.
In the Constitution, officials of state derive their powers from legislative and regulatory provisions. If they don't comply, then they exercise powers they don't have. That's
so I think you misunderstand me, my lady. Ostensible authority is a way to confer authority on those who don't have it because they've represented they have it. They can't represent to us through their representation an authority which they don't have and which will not be enforceable. I'm not suggesting that ostensible authority will rescue those who relied on the estate. The question is not so much whether by their own misrepresentations they can lift themselves up by their own bootstraps and create a legal act. What I'm suggesting is that those who deal with the state, when you look at the state of mind And when you look at the consequences of what an invalid tender might be, you shouldn't place blame necessarily on those who rely on the estate, because I'm submitting to you that in the ordinary course of dealing with the estate, never mind whether ostensible authority can create a valid contract out of an invalid one, because it clearly can't. But I'm submitting to you that we can work on a presumption when people deal with the state that they do their work. We have to do our work. They must do their work. And part of that work, which we're entitled respectfully to assume that they do, is that they comply with their internal formalities. How are the third parties to know whether they do or don't? That's the limited point I make. I don't think it takes me home to tell you that if it's an unlawful tender and there's disobedience to the prescripts, that it makes it lawful because they said it was lawful. Just saying, when you look at the state of mind of the parties and unknown to us, then I'm coming to the next point, my lady, is the idea.
Before you move, Mr., let's just look at that argument with reference to one of the grounds relied on, failure to comply with the requirements to submit the SIRA certificate, right? We are told two entities within the, no, this is not your client. This doesn't apply to your client, right? No, it doesn't apply to your client. Does it?
No, I think you're talking about the second tender, which Mr. Sedani will.
Okay, so it doesn't apply.
But we're going to submit to your ladyship that whatever may have been the position there, that's not a serious lapse. But
if your client, let's just use it hypothetically, if your client does not comply with a prescribed requirement.
So
clearly it knows that it does not qualify for the tender.
Yes, so my lady, there's a difference between a prescribed requirement and a tender requirement. If the tender requirement says that all bidders must produce a security certificate and they don't produce it, or they must be insured, or they must have empowerment credentials of whatever criteria the tenders, those are tender conditions. If you don't meet a tender, you shouldn't expect to be appointed. But if you're appointed, there may be consequences to that. What I understand my learned friend for the SIU's case to rather be is that in the background there are prescripts, other kinds of prescripts, limitations imposed by the Treasury, an inability on the part of the DCS to appoint an IDT as an outside implementer. That's what he's saying. He's also saying that the prescripts for a single source appointment weren't present. The urgency wasn't present. Those are not things which would be known to the tenderers. What they know, your ladyship is respectfully correct, what they know is that if they don't fit the qualificatory criteria, there can be a challenge to whether they should be appointed. I mean, that's a different issue. If you take all these reports, the armaments that the state can bring to bear in making a case of this nature, you've seen the confirmatory affidavits and reports and thousands and pages of different institutions that have given the SIU input, as is appropriate, because they're all part of the apparatus of state, and every citizen would want to see an end to corruption. It's entirely appropriate. The only limited point I'm making is that we're in a disadvantaged position because all of this is being decided on motion. Now, with regard to the IDT and the missing trustees, my lord, the conventionally, may I say this, you'll see some movement in this regard in the heads which the SIU hastily assembled in response to the late filing by the seventh respondent. And one of the issues they deal with in those heads is how to cite a trust, what's the most recent law on it, what to do about it. So trust law. Let me say a couple of things about trust law. And bearing in mind, in this application, the SIU are the applicant. The IDT is a respondent. So if the IDT have not been cited properly, it's in the first instance a matter for the respondent, that respondent, IDT, who are represented by Mr. Becker. And in the second instance, it's a question of joinder for your ladyship. If the IDT were an essential party to be joined, and they have not been properly joined in the sense that they have not been properly cited, or the people who represent them have no authority to represent them, then we're dealing with an inadequacy of joinder. So what my learned friends for the SIU have submitted to your ladyship is that they are sufficiently cited. They cite in authority for that, which is the Tusk case, which relied in turn on the Hyde case, which is a judgment of Mr. Justice Rogers. So traditionally, and the courts have been quite insistent on this, traditionally, you could not easily, can I say just easily, because there are instances where the court did accept it, but the more correct way was always accepted to be that the citation of the trust should be in the form of citing its trustees, because a trust is not a separate legal persona. It's an aggregate, said Justice Cameron in the Parker case, of aggregates and of an aggregate of assets and liabilities which are managed by trustees in the interests of third parties who are beneficiaries. That's in the nature of the beast. It's not like a company which is a separate persona. So how do you cite a trust? Conventionally, you would have to cite all the trustees. And there's sense in it. There's real sense in it. For the reason that unless you cite all the trustees, you don't know that the full complement of persons who purport to represent the trust are in fact representing it. So my learned friends for the SIU say, well, hang on a minute. There's the Tusk case relying on the Hyde case, and now you can just say a trust. To some extent, that is correct, and to some extent, it's not correct. In the Tusk case, which is the SCA decision, you'll see that the point was raised that the trust had been cited as a trust and not by the trustees, and an amendment was sought to introduce all the trustees into the citation, which the court au quo refused. So then what happened is, on appeal, it was argued by those in favor of the court au quo's judgment that it was a nullity. You can't fix it. It's unfixable. So what the SCA decision actually says is it's not unfixable. It's not so much of a nullity to cite a trust up front that you can treat it as a nullity. What the SCA did was they allowed for an amendment. If you look at the relief which was granted, they allowed for an amendment to introduce the trustees. So in the end, what my learned friends for the SIU are saying are correct. And you can only cite, you can just cite them by citing them as a trust, and you don't need the trustees anymore. Why did the SCA grant an amendment? It would have been completely unnecessary. And in the judgment of Mr. Justice Rogers, there wasn't really a debate at the end of the day about all the trustees, because they were all in one way or another before the court in affidavits and so on. He expressed in principle the view that you don't actually have to cite all of the trustees. But while approving that, the SCA said, look, we're prepared to accept that it's not a nullity if you sue it as a trust. You can fix it. Justice Rogers is right. You can fix it. Justice Rogers goes a little bit further than the SCA went. They say you can fix it, and they're going to develop the law to say you can fix it by citing a trust. But in the end, what they did is they still granted the amendment. So what we have here is different levels of a trust problem. In the first instance, you have to look at exactly how they did cite the trust. So if you go to the notice of motion and you go to the founding affidavit, the way that they cited the IDT is that they cited them by calling them an implementation agent. My lady, I'm told that it is 1 o'clock. I hope I'm not intruding. Would you prefer to take the lunch break, or how would you like matters handled?
I'm more concerned about time overall.
We're completely in your hands.
This hearing, you've been arguing for almost an hour, which is approximately what Mr. Motebe argued for. How much more do you need?
I'll speed it up, my lady. But remember, Mr. Stiliano is going to make a few points. I'll just ask him how long he's going to be.
I don't think it'll be more than 15.
He thinks it'll be about 15 minutes. If you gave me maybe another 15 minutes or so, I think I'll probably be able to wrap it up.
So would you like to complete the IDT citation point and we break for lunch, or should we break now?
We can quickly finish it. I'm not going to dwell on this, my lady. It's going to be another 5 minutes. I'll be done on this point. I'm completely in your hands. It doesn't make any difference to me to do it now or later.
Okay, let's break now. Let's break now. And is it fine if we come back at 1:40?
Yes, of course, my lady. Whatever suits you will be fine.
Just break for 30 minutes.
It's in order, my lady.
Mr. Bolo? Mr. Becker?
Sorry, my lady, I got tongue-tied there with my computer. For me, there's no problem.
Thank you, my lady. Appreciate it.
Thank you. We'll be back at 1:40.
Okay. there were monies that were paid pursuant to the cancellation. The cancellation that occurred of the first tender at the instance of the IDT and which had contractual consequences, including the payment of money. I want to make the first point. My learned friend for the SIU was at pains to point out that he wasn't seeking another cancellation of that contract, because of course that would be impossible. There's the contractual impossibility of cancelling a contract twice. But I want you to say to me, there may also be a contractual impossibility of declaring a contract that has already been terminated to be void ab initio, because it's over. It's over. Once a contract has been terminated, it no longer exists as a legal instrument. It has been cancelled. The parties to that contract have entered into commercial arrangements with regard to monies that should flow as a consequence of that cancellation. So I'm struggling to understand the basis upon which an already cancelled contract can be determined to have been void ab initio, because the contract is over. On any version, it is over. It doesn't help to say I'm not looking for another cancellation. He's looking for another termination of something which has already been terminated. Make that point and another that follows alongside it. And that is, there was some criticism, I understood, my friend, about a penalty payment. Just to make this very clear, my lady, the amount of money that was exchanged in this regard, pursuant to the cancellation, was not in terms of any special, extraordinary or unusual contract for the kind of engineering services that were rendered. That was the standard contract that is being employed by the profession. It's endorsed by the profession. So it's not, you shouldn't be under the impression that there was something wrong with the payment that was made. And if you want to be more specific, my lady, you can look at 005-104, which explains in paragraph 177 onwards how that normal professional contract works, that it divides the stages of work into 6. So you assess, if it's terminated early, you assess what stage has been reached, and you get a payment that is specified in the standard contract for the stage that has been reached and in accordance with the formula. That formula entitles a scale of fees, which is calculable in terms and on a tariff. If you look at paragraph 182 at 005-105, the way that the amount was paid is calculated in accordance with that standard contract. And you'll see at page 005-106 that only stages 1 to 4 were completed, not stage 5 and 6. The Sikelec people were not entitled to claim the full amount. They had to do it on the basis of acknowledging the stages that were reached. And so there was an amount which was calculated and halved because only 50% of the contract had been completed. And there are surcharges that are chargeable under the normal tariff. This is not some kind of a special punitive penalty. And in fact, if you look at paragraph 184, 005-107, there was a voluntary discount of 2.5 million rand that was given. And part of the payment was that it was known at that time that there would be another contract which would be awarded, and that there was an amount of compensation in respect of the intellectual property that would be used. So I don't know if my learned friend meant to be critical about it, but it's all fully explained in chapter and verse over a series of paragraphs with calculations and and explanations which are in full, and it does meet the test of Plascon Evans. This was not something which is seriously or inherently improbable in accordance with the contract. So, my lady, those are the submissions. The one thing I would just point out to your ladyship, perhaps my learned friend for the SIU can reconsider this. In the accounting phase, if their relief prevails, they're talking about a 30-day period for this accounting, which is a massive exercise. But it is not a realistic possibility. Perhaps my learned friend for the SIU can take it on board and reconsider what would be a reasonable period if he's fortunate enough to succeed in the relief he seeks. But of course, we say all relief relating to the first contract, for the reasons I've argued, should be dismissed. My learned friend will tell you about the second contract, Mr. Steliano. And as far as costs are concerned, there is no basis respectfully on which we should be attracting any costs. The IDT, if they're to receive any money, are the cause of all of this misfortune. They are the people, if anyone, who should have to pay the costs. And if the SIU is unsuccessful in their contentions, either because they exceeded their limits of their power under the proclamation, or because there's an issue of prescription, the cost should then follow that event. And then perhaps I can hand over to Mr. Steliano, unless your ladyship wants to ask me.
In your view, what would be the reasonable accounting period?
If I may, can I take an instruction from that? I'm not exactly sure what would be involved, but during the course of it, we can perhaps announce to you what we'll tell you in the course of the afternoon that's suitable to you.
Thank you. Mr. Steliano.
Thank you, my lady. Your ladyship would just bear with me for a second. My lady, I just want to address, and I'm mindful of the time constraints, so I'll try and be brief as possible. I want to just address the second tender, which I'll call tender number 2. And in particular, whether or not Bakoni Sekelek, the 3rd, 4th, and 5th respondents, knew that they were not compliant. Now, our learned friends for the SIU only dealt with one aspect of. I see I'm a little bit out of focus, my lady. Can your ladyship see me? Don't know why.
I can see you, but the vision is not there.
Thank you. Sorry, we're just going to try and fix that, my lady. Our learned friend for the SIU only addressed you on the question of the professional indemnity.
Thank you.
Oh, so, yeah, thank you, my lady. Short. The question of the professional indemnity cover. Now, my lady, your ladyship asked my learned leader whether or not SIU, sorry, the joint venture could have really believed that they were compliant when they knew that they had complied with the tender requirement. Now, I'm also going to take your ladyship to the tender requirements. Your ladyship will find that at 001-1731, my lady. And there your ladyship will see that the requirement was proof of indemnity insurance of 15 million rand or letter of intent / quotation of 15 million rand or above. So the first thing that's apparent is this. Yes, we accept that we didn't have 15 million rand in cover in place, but that's not what's required. It's either 15 million rand or a letter of intent or a quotation for the 15 million rand. What we do know is that there was a competitive bidding process for the second tender. And we see that at page 001-50, paragraphs 115 to 117. 117, I can just read quickly to your ladyship. Accordingly, according to the tender evaluation committee minutes for SP02, 15 bids were received and 6 bidders were disqualified, 5 due to insufficient PI insurance and 1 bidder due to insufficient proof of data. As communicated to all bidders, clearly stated that professional indemnity insurance of 15 million rand was required as a precondition in order to not to be disqualified. Proof of the PII had to be attached to the bidder's proposal. As stated above, other bidders were disqualified due to insufficient PII. Now, that is not quite correct, my lady. The SIU says that at page 001-52, paragraphs 121 to 122, your ladyship can see from the requirements that it was either the 15 million rand or a letter, or a quotation or a letter of intent. So now the important thing is to see exactly what Bakone Sekelek JV had actually presented to the tender adjudication committee. Now we see from the tender evaluation sheet of Bakone Sekelek, which your ladyship finds at 001-1687, that the valuer, according to the SIU, had mistakenly stated that it complied with the 15 million rand threshold. Now, my lady, again, the SIU is relying on the evidence of other people to garner this information. And who do we see them relying upon? They rely upon two confirmatory, or 2 affidavits, one by Mr. Mokobane, which your ladyship finds at 001-1664, and Mr. Moketi, which is at 001-1670. Now, if your ladyship has regard to these affidavits, it's portions of the affidavit that I wish to draw your ladyship's attention to. Paragraph 6.1.4 to paragraph 6.1.8.6 are identical. They couched in the same language. So they state in their affidavits, identical in all respects, Igoba projects, because of insufficient professional indemnity insurance, were disqualified. Now, it seems highly unlikely that 2 individuals would couch their affidavits in exactly the same way. So I would submit that it's important to consider exactly what Igoba had presented to the tender evaluation committee. Now, my lady, your ladyship will find the letter of intent from Igoba at, should bear with me. I don't seem to have the reference for that. I'm just going to try and find it quickly. I won't be. Ladyship will bear with me. Well, perhaps I don't need to, while I'm searching for that, waste your ladyship's time. I can take you to what the quotation from Bakone Sekelek says, my lady. Your ladyship will find that at page 005-1246. Your ladyship there sees that there's a letter of intent from the insurer that gives a quotation for option A, option B, and option C. Option A is for 10 million rand cover, option B for 15 million rand cover, and option C for 20 million rand cover. And on the next page, at page 1247, option A, the premium is recorded as 175,000, option B, 250,000, and option 3, 300,000. So that, I would submit to your ladyship, is a quotation which is in compliance. Yes, it's fine. Which is which renders the tender compliant.
The crux of the SIU point is not that the Bakone JV did not qualify, but it's that Igodi qualified but was disqualified, wrongly disqualified.
Yes, my lady, but that's why I need to take your ladyship to their quotation, because my submission to your ladyship is that their quotation is in fact not a quotation. I'm trying to find it. If you'll bear with me, I thought I had a note of it, but I don't seem to.
If I may assist, my lady, is Annexure CD 13 at page 001-1749.
Thank you.
I'm indebted to my learned friend. Thank you. Unfortunately, this the bundle is such a big bundle, my lady, that I think these computers are struggling to deal with it. So, my lady, if we look at the document that IGOBA had submitted to the Tender Evaluation Committee, it says, we confirm that we are the professional indemnity insurer brokers to IGOBA Projects Pty Limited. Our client has advised us that they are tendering for the above-mentioned project, and in the event that they are successful with the bid, then based on the available information and subject to insurers' support, we will be able to put in place the necessary 15 million rand cover for their involvement in the project. It's not a quotation, my lady. In the same way...
Is it a letter of intent?
It seems to be a letter of intent, but it's... your ladyship will have regard to the requirement, which was a letter of intent / quotation. So I would submit that the letter of intent needs to be something which indicates what cover would be available and at what price. So that it is something that is, it's really just a question of making payment of the quoted amount in order to receive the cover. What this letter is more importantly, it's qualified. It says subject to the insurer's support. It's therefore not a quotation. It's therefore not, it doesn't qualify. It's not a letter of intent / quotation, because we don't know what those conditions are that the insurer will require or might. What authority are you relying on for that proposition? My lady, it simply
it clearly says that based on the available information, it's got conditions clearly, but it clearly says that they will be able to put in place the necessary 15 million rand cover for their involvement in the project.
My lady, but there's no price, there's no quote. So it's a letter of intent / quotation. So what we want, what is required is 15 million rand cover or a letter of intent / quotation. They're grouped together. So you read it together. You have to show a letter of intent to put it up, and you've got to tell me how much you're going to pay for it. And it's got to be unconditional. That's why I would submit that the quotation is necessary. You need to know. Now, my lady, it's an interesting debate, but at the end of the day, it's really just to address what your ladyship asked my learned leader earlier, was Bakone Sekelek JV couldn't have thought that they were compliant when they knew that they didn't have the PI cover. They wouldn't have known about IGOBA being disqualified for whatever reason. We know from Magnaletti and what they say in paragraph 127 of their affidavit, they say IGOBA projects and Element Consulting were disqualified because of the various onerous and unrealistic conditions proposed in the letters of intent. Safe to state, as aforesaid, the allegations are denied. That's at page 005-36. So they see it the way that I would submit your ladyship needs to look at it, that this was not a letter of intent or a quotation. This was a conditional letter, so it didn't qualify them. So they were properly disqualified from the tender. But in any event, it's really just to go to the point that that your ladyship put to my learned leader about whether or not Bakoni Sekele could have been bona fide in believing that they were compliant.
Yeah, that question was in a particular context. You will recall from All Pay that the innocence of a tenderer is actually relevant to this exercise, right? And that court specifically warned that irregularities may be indicative of, I'm trying to remember the particular wording used, whether it's corruption or whatever.
Corruption, I think it was corruption.
I think it is corruption. So that says to me that, you know, in proceedings such as these, we shouldn't, in fact, it's quite clear from that aspect of the judgment that irregularities, tender irregularities should not be taken lightly, right? Once an irregularity is established, then the tender is reviewable, because those irregularities could well occur because they are masking some other more serious malfeasance.
I understand what your ladyship pleases. The point, though, that I think needs to that your ladyship should bear in mind is that it's not. My submissions to your ladyship are in respect of what the appropriate remedy should be. Whether your ladyship.
Yeah, we're not there yet.
Yeah, well, yeah, but that's where I'm getting to, my lady. So, if your ladyship finds that Bakoni Sekele was unaware of any irregularities, then your ladyship's discretion should be exercised in a certain way, is the submission.
That's what Pumela says, right? But All Pay says, if a tender is set aside, nobody should profit from it.
I would submit that's not quite correct, my lady. If your ladyship looks at Pumela, and now it might be a good segue to go into Pumela. If your ladyship looks in particular at paragraphs, does your ladyship have the judgment available?
I've got it somewhere. I didn't pull it out for this hearing. Let me see if I have it close by.
Sorry, my lady. Incorrectly, my lady. And your ladyship will bear in mind that the All Pay cases were in 2014. 4 years later, the Constitutional Court in Gajima says, yes, we will strike down the contract, but we'll preserve your contractual rights. Now, those two judgments can't stand in the face of each other. If the one says is that tender irregularities means you've got to strike it down and everything goes back to zero, you can't read the two together without conflict. So I would submit that the position adopted by His Lordship, Mr. Justice Gorvin, in Pumela, it traverses the middle way between those two positions. He says in paragraph 18 of the judgment, a careful and contextual reading of All Pay 2 thus shows that the Constitutional Court did not hold that a party could derive no benefit from an unlawful contract. The approach in All Pay 2 of allowing a party to retain payments and thus to benefit under unlawful contract has been echoed in a number of matters, and that the footnote there is to Gajima, footnote 17. See, for example, Gajima, paragraph 54. One such example is found in Buffalo City, where the majority in the Constitutional Court held, I therefore make an order declaring the recent contract invalid, but not setting it aside so as to preserve the rights to which the respondent might have been entitled. It should be noted that such an award preserves rights which have already accrued, but does not permit a party to obtain further rights under the invalid contract. There too, says Judge Gorvin, the contractor had performed its obligations under the contract. The Constitutional Court held that the contractor was entitled to payment for the work which had been done. Therefore, it must be said that the principle relied on by the SIU as set out in Mott MacDonald is no principle at all. The same must be said of the following dictum in Central Energy Fund. The dictum is the second guiding principle is the no profit, no loss principle, which the court articulates as follows. It is true that any invalidation of the existing contract as a result of the invalid tender should not result in any loss to cash payers. The converse, however, is also true. It has no right to benefit from any unlawful contract. Now, in dealing with that passage, His Lordship Justice Gorvin says, deriving as it does from the same dictum in All Pay 2, it is clearly wrong and should not be followed. Therefore, the failure of the High Court to apply the principle relied upon by the SIU does not afford a basis to interfere with true discretion. Now that comes to paragraph, so that's in paragraph 19 of the judgment. In paragraph 20 of the judgment, the Supreme Court of Appeal talks about the discretion that your ladyship has in this particular instance. The discretion is the wide discretion, the wide discretion type, the true discretion. They say that because there is true discretion to be exercised under